Yes, please.
My lords, I hear we are challenging the impeachment order passed by the family judge Nayagat, my lords.
Your full name, sir?
Abhilash Sarangi.
Abhilash. Mr. A. Sarangi on behalf of SP Sarangi for the petitioner. Yes.
My lords, what has happened in this case, my lords? The petitioner has filed one 125 petition in the before the court.
JMFC section 125 CRPC.
Yeah. Yes,
Develops the habit of telling the entire sentence.
Yes, my lords.
Yes.
Before the learned JMFC G Udagiri.
Yes. Has it been allowed or rejected?
It was pending the melodies.
Yes.
In the meanwhile, she filed another petition in the court of learned family judge Nayagat.
Yes.
And in the meanwhile, she withdrew the petition which was filed in the court of JMFC G Udagiri.
Yes.
And the order was passed on date 25/11/21 by the family judge Nayagat, and she dismissed the petition on the ground of that the
lack of jurisdiction, imperial jurisdiction.
Yes, my lords.
In this sense, it should have been not filed, but it cannot be filed at Nayagat.
Yeah, no, my lords. Yes, my lords. They have. She has reflected in the order that the same on the same ground she cannot file two petitions at the.
That is correct.
Yes, my lords.
That is correct. But is it your case that when the second matter was taken up, earlier matter was still pending or disposed of or withdrawn?
The matter was withdrawn.
First matter.
First matter was withdrawn.
Date when the first matter was withdrawn.
The matter was withdrawn on the memo was filed on 15/3/21. Order was passed on. Proceedings.
Order allowing the withdrawal.
Yes.
By the court at Udayagiri. G. Udayagiri.
Yes, madam.
You take page 23.
23. It was order dated 26/3/2021.
10/4/21.
The petition as well as the opposite party.
26. It's 10/4/21.
She appeared before the court on 26/3/2021, and the order was passed in 10/4.
No,
my lord. 26/3/2021. The order was passed.
21. Can you read the order? Page 23.
The petitioner as well as the opposite party appeared in the person before the court today.
He appeared on 10/4/21. Yes, please read it. Before this court,
the petitioner is filed a memo and ordered on dated 15/3/2021, stating therein she does not want both the parties. She doesn't want to proceed to the case since they are compromised outside the court. Heard both the parties. In the view of compromise between both parties, the matter has already been settled. The case is withdrawn. The matter was not settled, my lord.
You are not getting it, sir.
Yes,
matter was not settled. Can be a plea before the trial court. As for the appellate court.
Yes, madam.
So if you are challenging that 10/4/21 order, whom you should draw notice? Because I can't substitute the JMFC G. Udayagiri. I'll continue to be a judge here. I cannot form opinion on his behalf. Have you drawn this? You want 10/4/21 G. Udayagiri, but you are taking advantage of your contention is because of 10/4/21 the subsequent petition before the Nayagat court.
Yes, my lord.
Is maintainable.
Yes, my lord.
Before the Nayagat court in the petition, have you disclosed 10/4/21 order?
Yes, my lord.
Where? So your plaint before the Nayagat court? Or I'll pass over. You'll go through the dates.
Okay, my lord.
ଦେଖନ୍ତୁ ଆପଣ ଆନେକ୍ସର 3 ରେ ଦେଖନ୍ତୁ ଆପଣ କୋଉଠି ଲେଖିଲେ not mentioned.
Not mentioned. Sorry, my lord.
Then how the court will know? unless court is Sarvagya or have a divine kind of that without looking at the pleadings.
Sorry.
No, why should you be sorry? Never be apologetic because you are holding a brief. It's a courtroom discussion. Why should you be apologetic? We have to deal with facts. And obviously, facts are true always. So then what happened?
Due to the
Did the husband opposite party file a written statement before the court at Noagarh stating that you have already filed a petition?
Yes, my lords. Yes,
Do you agree?
On basis of that only, she has
So
passed.
written statement dated?
Written statement dated,
Just look at page 30. Order dated 25/11/21. 10th line from top. It reads here the petitioner. Read that.
The petition says to file certificate.
So you have to read it aloud because you see
Petitioners filed
I will do it myself. You are reading for the court.
5, 6, 7.
Here the petitioner has filed.
Here the
petition.
petitioner has filed the petition under section 125 CIPC and 10(3)21, on which date was still pending before the learned JMFC G. Udagiri. As such, she has suppressed such fact and filed this petition. In support of her above contention, the learned counsel by the petitioner.
What can be done, sir? You have seen that 10(4) is the order. And the basic facts you have to take care of.
Yes, yes.
When you are placing the matter, these dates and all these things. Now, then you should have clearly stated that I have already withdrawn. Actually, what has happened before withdrawing, it has been filed. The observation is correct.
Yes, ma'am.
After filing, when you have withdrawn, you should have brought to the notice of the court. Or you have filed another petition stating everything. When it was dismissed.
It was
25/11/2021.
Yes, ma'am.
So 125 CRPC is a continuing cause of action or can be a phrase every day, fresh cause of action. Every day you can file a petition.
Yes,
Today there is no maintenance is given. Tomorrow not given.
yes, ma'am.
After 1 month it is again not given. So there cannot be a res judicata 125. But when you file two petitions simultaneously at different courts, then which court will adjudicate? That concept is not there. So you
Right
take
now, I am
action.
nowhere, my lords. Both the petitions has been one has been withdrawn and one has been dismissed. So I am nowhere right now, my lords.
No, you are definitely on earth before the court, now before the High Court. Before filing the petition, you moved around actually. The status you are facing today, you should have been static.
Yes, yes.
Being static, you should file the petition. You have chosen different forums, different times, different orders. Court can't do that. Court have a limitation. And you should not, and in fact, you have not defended your case well in before the learned trial court. When the trial court, first of all, you have not mentioned anything. Suppose you have not mentioned anything, after withdrawal, you should have filed an affidavit before the trial court.
Yes, ma'am.
This order cannot be faulted with. To find fault with this order will be a faulty order by me. So you adjourn it, ponder over these facts, get your, gather your thoughts, talk to the person, and then you come back.
Okay, ma'am.
Had learned counsel for the Mr. Abhilash Sodangi for the petitioner. The petitioner wife in the marriage is before this court. Challenging the order dated 25/11/2021 in CRL MP number 46, CRL.M.P. number 46 of 2021. Passed by the learned judge family court. You take your seat. I'll take some time and dictate it. Okay. Passed by the learned judge family court, Baragar. The said CRL MP was disposed of by order dated 25/11/2021. कौन लिखले सेंटेंस टा ता पूर्व सेंटेंस टा अविनाश तो सेठी तापरे passed by the learned judge लिखले हा तापरे से तापरे से insert करंतु the petition was filed by the petitioner wife in the marriage under section 125 CRPC into bracket since repealed and substituted by parliamentary provision in Bharatiya Nagarika Suraksha Sanhita 2023 bracket closed. तापर एटा लिखले by order dismissed by order dated. Yes. The ground of dismissal of the petition is that the opposite party husband in the marriage raised issue of maintainability of the petition before the Court of Learned Judge Noyagarh. When the petition MC number 45 of 2019 filed before JMFC, G. Udayagiri in the district of Kandhamala was pending and the serial MP 46 of 2021 was filed before the Learned Judge, Family Judge Noyagarh on 10/3/2021. Apparently, the facts regarding pendency of the petition before the JMFC G. Udayagiri is correct, in as much as the petition was withdrawn by order dated 10/04/2021, as is evident from the order sheet annexed to the present application. The Learned Counsel for the petitioner has adjournment. List in the week commencing 2 March. 2 March ना आगु चाहूँगी.
In the month of April,
एप्रिल ले कौन होगा? आपण बुझपार नांती जे आपण काली जाए कि आउट पिटिशन फाइल करिया कथा जोटी चाहूँगी. Maybe at Cuttack, at Puri or Puri. Because for filing 125, we are moving around. I will check what is the provision for the territorial jurisdiction of a court. You have 125.
no,
You should read. 126
Yes,
is very clear. It can be filed at any place where the person seeking maintenance resides.
yes,
So that is the. Initially I thought that on that ground it has been dismissed, but actually it has been dismissed due to filing of simultaneous petitions at 2 places.
yes,
And you should have taken care there that the earlier application has been already disposed of as withdrawn.
Let it come on 5th of May.
So that you at least you do not pursue, because here you are again in a situation, as you said, you are nowhere.
Yes,
You are nowhere because you are pursuing too many things simultaneously at different places. So now you have to file a petition. That is my understanding is that you can file a 125 petition afresh. 3 March we commencing 3 March कर लेना. 2 March को दिए 26.
published.
Yes, next.
Item 2.
अर्जन कर दियो, पोस्टिंग कर दियो.
Item 3.
लीडरशिप रे मेंशन कले. सुमहांत मेंशन कले. आपण नोटिस करना आंदी बोलते सुमहांत वाज प्रेजेंट. डेट करना आंदी. कर दियो.
With commencing law.
दुईटा कले.
Sorry.
हां. ठीक है.
Item 6.
Mr. Vishnu Brata Singh for the petitioner. Opposite party plan. Yes, Mr. Singh.
The order of the permanent locador can be challenged in a writ application,
Ground.
my lord. Here I am challenging the no pendant and interest has been granted, my lord.
That I have heard.
Yes, my lord.
To check the case law on this.
Yes, my lord. Regarding your stated whether the writ is maintainable, there is a decision of the Supreme Court and or High Court, my lord. If the writ can be
Sir, I never said it is not maintainable, sir. Please don't. I may look like or talk like a fool, but at least publicly don't say that I asked whether it is maintainable or not. What is the case law on this?
the case is, my
So
lord.
you notion and how I will say. The law is very clear. It is the only remedy or it is the remedy. State of Punjab versus Jalor Singh.
Yes, my lord.
So how I will say after reading you are unable to recollect, I am able to recollect. I will say that it is not maintainable. But saying not said it is not maintainable.
No.
Then what is the next decision?
It's my lord regarding the pendant and interest, my lord.
Not pendant and net interest. After the scope of interference, after you agree for a settlement, pendant and net interest, if you said that, then what is you have to read that.
I am not agreed, my lord.
Sir, unless you read those decisions, you cannot argue the matter.
No.
You have to prepare yourself.
No, yes, my lord.
You will only say that my lord said this back.
No, my lord, the permanent
Sir, you are not listening. That is not registering.
permanent locada has power to dispose the case on also merit, my lord. That is
Sir, let us not.
22D.
This is not a class where you will go on academics. Who is saying that permanent doesn't have? Have you agreed for the accepting the decree or not? That is the question asked to you.
I am accepting because
That's
of
it.
challenge only the interest.
You cannot.
He has granted, the PLA authority has granted interest, failing which if not paid within a
Pending the light,
6%.
if you are agreeing, this court lack jurisdiction in entertaining your application because of first decision is judgment is Jallo State of Punjab versus Jallo.
Yes.
Second is
Another recent decision also Supreme Court of.
that the cost title is not the recent decision. I am asking you the cost title. Bhargavi construction. The law is very clear. This court cannot change.
Because of he
By
has,
saying that, my lord is saying writ petition is maintainable, but not for altering your agreement. Suppose you look left, then right, then straight, then left. Then what the court will do?
don't limit.
What are the ingredients of challenging?
It
What
is limited purpose also.
they
That
are not limited purpose.
then the
You
order.
cannot second guess a judgment. The judgment is very clear on which grounds you can challenge
Yes.
the PLA. Not seeking extra money or reducing. Suppose now the other side will come. Why
No.
your client has Narendra Mishra will claim this much?
Issue
You must
notice.
answer.
My issue notice.
No, I cannot. I should not.
Notice, mal. Only
Because my difficulty is that
delay because they are not paid. I have run to the court for
the
3 years pending a
issuance of
report.
notice will be by illegal order. I will not. If you have a case law, what is the third decision on this? The Justice Pardiwala. Are you reading that?
No, that is Dilip Mehta.
Wherein Dilip Mehta, it is stated that by filing a writ application, interest will be claimed.
No, that is
That's the problem, sir.
That's the remedy.
This is a branch where
Because-
what you are proposing that this court will only issue notice
issue.
illegal. I can record that because to reject your contention it becomes easier for me. There are so many decisions, and perhaps that is how you are repeatedly saying writ is not maintainable. My lord asked why writ is.
No.
Writ is maintainable, but entertaining and issuing notice and there should be some reason in interfering with. Mr. Singh, you must understand how much effort is made in this local settlement. It is monitored by Supreme Court, High Court. Then SLSA, State Legal Services Authority, District Legal Services Authority, and Lordship may kindly issue notice so that all these efforts are thrown to
Because
dust.
of for the insurance company, delay was made, but they have not.
Sir, you have forgotten that I am not the Lok Adalat. I am a read court. I am exercising supervisory jurisdiction. I am
Yes.
preferring to spoil the efforts. It takes lot of effort. You are regularly appearing in Lok Adalat, I have found. In conciliation, pre-conciliation. To spoil that by a High Court judge is completely illegal, sir. No semblance of respectability or legality in such a order.
Normal Lokada and the PLA, permanent Lokada. Normal Lokada has no power to dispose the case on merit, Mala. Permanent Lokada has power to dispose the case on merit.
Sir, instead of giving a speech which is recorded and watched by public, state some law that whenever permanent Lokada passes an order.
Statute, Mala.
So you have not read the statutes, I have read it. You have not, neither you have read it, nor you have checked the case law.
That is a 22D and 22E, Mala. 22D procedure of permanent Lokada.
Sir, I am not the permanent, sir, I am read court, sir. I am asking you the scope of interference.
So,
Sir, you have only one case. So I have to look at so many cases. So if I can prepare, then why not you? Suppose now I refer to 22D and issue notice. Let us say, I accept your contention. On the face of it, it is a absurd and illegal order. Should I do that? And that adds to pendency.
because of due
You see,
negligence.
you have some 100, 200, 500 cases. This is not the only case with you. Is it not adding to the pendency that a person is adopting a illegal course? That after agreeing at the permanent local, then Mr.
I'm not agreed. That is a disposal of merit matter. Merit matter. They have rejected against
Have you realized the court, the judgment says there is the permanent local order can be challenged in appeal.
There is no such provision in the. There is no such provision. From before.
I did not say provision.
No.
In certain circumstances,
To before whom, before what is the provision?
I can become your associate of briefing counsel. To that extent, even the law is there. You are arguing that REIT is maintainable. You can argue appeal is maintainable. Sir, I am not doing any favor to you. You are fighting for somebody's right. Does the court have option? Perhaps I am giving the impression that larger than life, I am doing something. I am not doing any grace to anyone. The person has a right, I have to. That should be your approach. Nothing. So that is how I gave you a chance on 15-1. Maybe you will read those cases. You have not looked at even. So what do you want, sir? Disposal on merit or perfect, or you want adjournment or
Disposal.
disposal? Okay. Kindly take your seat. I'll take some time in dictating. Complete. So Vishnu Brata Singh for the petitioner, opposite party blank. Can you take your seat? I'll take some time. You don't have to stand while I'm dictating. Why should you? You take your seat. Order dated 15/1/2026, para 2, 3. By order dated 15/1/2026. The following, after hearing the council at length, the following observations were made. Para 4 टा तापरे quote करिए. अपन प्रथमरु ये कले had learned counsel for the petitioner. Today 1, 2, 3 गला. चारिटा को quote करिए. ହେଲା. Today the matter is heard again. Act out रे कहिए. जो आठ आपण पढुଛନ୍ତି ସେଟା ସେଟା କାढ ଏଟା ଦେଖନ୍ତୁ ସେଟା ଆପଣ ରଖନ୍ତୁ ଆପଣ ହୋଇ ଦିଅନ୍ତୁ The learned counsel for the petitioner refers to section
22D and 22E, man.
22D and
is
E.
the award. 22D is the procedure for permanent local.
Refers to 22D, section 22D and 22E of the Legal Services Authorities Act 1987, which are reproduced herein. It is submitted that the permanent Lok Adalat has authority to decide ଆପଣ କହୁଛନ୍ତି କଣ merit ରେ କରିପାରିବେ ନାହିଁ ନା କରିପାରିବେ
ଲେଖା ହେଇଛି merit କରିପାରିବେ every award of the permanent local under this act made either on merit or in terms of the settlement agreement shall be final and binding.
ସେଟା ତ ଆପଣଙ୍କ against ରେ
That
ସେଇଟା କାଇଁ ସେଟ୍ ଆପଣ ଗୋଟେ ବଢିଆ ପଏଣ୍ଟ ଗୋଟେ କହିବେ ନା ଆପଣଙ୍କ ଫାର୍ଷ୍ଟ ପଏଣ୍ଟଟା
it has been compromised ହେଇଛି ମାନେ ମୁଁ କହିଲି,
No, kindly read slowly, then you
I am not agreed. That was
No, you are not getting it.
sure.
Either or সেটা ଆପଣ মিস করে যাইছেন shall be the finality is attached both ways.
Procedure will also say the permanent
ପଢନ୍ତୁ ଛାଡି ପରେ ଅନ୍ୟ ଗୁଡା ପଢିବା ଆରମ୍ଭ କଲେ ଏଭ୍ରି ଆୱାର୍ଡ ଯୋଉଟା ପଢୁଛନ୍ତି ଆଉ ଥରେ ପଢନ୍ତୁ
every award of the permanent local under this act made either on merit or in terms of the settlement agreement.
So suppose you are saying that one award is not final, one award is final. That is not open here.
Not final. It is
final.
Agreed and non-agreed.
No, not non-agreed word ଆପଣ add କଲେ ସେଟା statute ରେ ନାହିଁ.
It is not a conciliation and not compromise. It was adjudicated on merit. I say it has been adjudicated on merit.
It is directly against you. If it is argued now, suppose now you turn around and take it to the bank. Let us forget the bank will come and say that we will not pay this amount. Just the same argument they will. So what will be the response of the court? Same thing. It is final. Referring to 22E, it is submitted that the petitioner can challenge the award before this court, seeking interest on the pendent for the period. The amount remain unpaid or pendent like quota coaching interest.
Pendent.
The interest for the period the matter was kept pending before the Lokadalat
Court.
In short, pendent stop kar diyo, stop. The scope of interference by this court in the award passed by the permanent Lokadalat or the Lokadalat at any level has been has attained has been settled in the decision in the following decisions. First, देखिए State of Punjab versus Jalor Singh. Citation देते पटना लिखिए. Sir, elaborate ପରେ କରାଯିବ. Vargavi Constructions, second. Then Mukund Bhavan Trust and others. Then Dilip Mehta. ଆପଣ ଦିଲ୍ଲୀପ ମେହତା ଆପଣ ବି କହୁଛନ୍ତି ଦିଲ୍ଲୀପ ମେହତା versus ରାକେଶ ଗୁପ୍ତା. ଆପଣ ବ୍ୟାଙ୍କ ପାଇଁ ନା ପିଟିସନର?
No,
you are appearing in this matter for the petitioner.
petition.
But you are arguing for the back.
Back,
22E, banks will say that even if the petitioner says on merit, final, no appeal. The problem is 22E makes, because even as I said, in some cases, appeal is maintainable. If you read those decisions, very limited, very limited. Because when there is no adjudication on merits, there can be appeal. But 22 makes it that even in appeal, on merits, final. The decision in the state of Punjab, Supra, has elaborated on the aspect regarding on which grounds the award of a permanent lok adalat, public lok adalat, especially the permanent lok adalat under the Legal Services Authorities Act, 1987, can be challenged. Para 12. Duly signed? Agreement sign करते settlement sign नहीं settlement sign नहीं para 12. Then Bhargavi. In Bhargavi construction, paragraph 33 of SCC online print, the following has been directed. এটা করে গেল কি মুকুন্দ ভবন ট্রাস্ট প্রিন্ট করে দেন ওটা তো ঠিক আছে ইন মুকুন্দ ভবন ট্রাস্ট রিলেভেন্ট প্যারাগ্রাফ তারপরে কোট তারপরে দিলীপ মেহতারে এটা আপনার আইএনএসসি প্রিন্ট সুপ্রিম কোর্ট ওয়েবসাইট At paragraph 14 of Mehta, Dilip Mehta Supra, the following has been laid out. So 14 and 15 কথা 14 কথা It is in the as a residuary submission, it is submitted by the learned counsel for the petitioner that this court can issue notice in the matter to the opposite party. So, obviously, that would mean without examining the matter on merits and without following the settled proposition of law as laid down by the aforesaid decisions of the Honorable Apex Court, the matter has to be entertained and notice has to be issued, which in considered opinion of this court is not permissible for a writ court to do. Accordingly, the petition is disposed of. Yes.
Item 7.
Cooperative টা আলগা রইবে না, cooperative টা আপনার আলাদা কোনো ইস্যু হবে।
May,
Yes, please.
may it please your lordship.
Yes.
Opposite party, husband,
ବହିଟା ଫେରିଲେ ଆପଣ ବହିଟା ନେଇଗଲେ ତ? Yes, please.
I have instruction to appear for the opposite party. My refer to pass over my.
I have objection. It will be hard, let them take whatever action. Because I have other briefs to attend.
ଆପଣ ପାସ୍ ଓଭର କଲେ କଣ ଏଟା ଫ୍ରେଶ ମ୍ୟାଟରଟା ସେଇଟା ଠିକ ଅଛି କଣ ସେଟା ଭୁଲ ଅଛି ବି ହେଇପାରେ ବଟ୍ ଆପଣ ତ ରିଜିନ୍ ଟା କହିବେ
No, my lord.
ଯେମିତି ଗତ ଗୋଟେ ମ୍ୟାଟରରେ କୁହାହେଲା ଯେ ଆପଣ ନୋଟିସ ଇସ୍ୟୁ କରନ୍ତୁ
No, my lord.
ତାପରେ ଗୋଟେ ଥିଓରି ଯେ ହଁ ଆସିଛି ଲୋକଟା ହାଇକୋର୍ଟ ଆସିଛି
No, my lord.
But how does it help the person? ସେ ଲୋକର ଗୋଟେ ଆଶା ସୃଷ୍ଟି ହେଲା ଯେ ଏଠି କେସ୍ ହେଲା ବୋଲି ସେ ପଡିକି ରହିଲା ଲୋକର ଲୋଭ ବି ଅଛି ସେଠି ପଇସା ନେଲା ତାପରେ ହେଲା ଟିକେ ପାଇଥିଲେ ହେଇଥାନ୍ତା ଇଣ୍ଟରେଷ୍ଟ କି ତାକୁ କିଏ କହିଥିବେ ଆପଣଙ୍କୁ କନସଲ୍ଟ କଲେ କି କହିଲେ ଯେ ଟିକେ ପଇସା ମିଳିଥାନ୍ତା ଅଧିକା କାହିଁକି ତମେ ରାଜି ହେଲ ଫେର ଆଉ ଥରେ ହେଲା ତ ଆପଣ କହିଲେ ଯେ ଏଟାକୁ ତାଙ୍କୁ ଶୁଣନ୍ତିନି ପାସ୍ ଓଭର କରନ୍ତୁ ହାଉ କ୍ୟାନ୍ ଆଇ ପାସ୍ ଓଭର ଦ ମ୍ୟାଟର ଆଟ୍ ୟୁର ଇନଷ୍ଟାନ୍ସ when it is a fresh matter that I'm asking you.
No.
Please listen what is happening.
Yes, ma'am.
And it is a good habit to think twice or three times.
I don't do something before till Mr. Misra coming.
I will caveat.
Yes, ma'am.
Caveat petition is filed.
No caveat.
Then I cannot postpone the hearing.
Mr. Misra. So
Madam, that is unknown, unheard of procedure.
okay,
That
let
the opposite party will decide when the matter will be heard.
no. Your
So please
lordship
don't make
take up
that.
matter.
Either you refer to some provision where I can do that.
No. Your lordship.
I cannot. He may agree. That's a different.
Yes, ma'am.
You may both of you may agree for that's a different thing. But I cannot at your instance adjourn the matter.
Okay.
Yes, Mr. Pujari.
My lord, may it please your lordship. Opposite party filed CP number 488 of 2018 seeking a divorce from the present petitioner wife. That was disposed of by judgment dated 22/2/25. Thereafter, in that case, there was no interim maintenance. This petitioner had filed a DB case seeking interim maintenance also. And in that DB case, the order was in a revision, page 11 may kindly be seen. This,
You have not filed an IA for interim order?
there,
ଆପଣ ଏଠି
80 no.
କଣ ଆପଣ କରୁଛନ୍ତି ତ କ୍ୟାଭିଏଟ୍ ବି ଫାଇଲ କରିହବନି
No, your lordship.
suppose you file a caveat also it is not because there is no interim prayer
Your lordship may I
you
place-
mean that you
May I-
cannot you file your petition to place it these innovative ideas how do you gather that you will argue your matter in the petition of the other side ଆପଣ ଯଦି କିଛି agreed by any order
Yes, ma'am.
you cannot preempt or preclude preempt a court from hearing
No, will not prevail.
so in fact I'm baffled ଆପଣ ଏଥିରେ interim prayer ନାହିଁ
No.
ତାଙ୍କର ଗୋଟେ ପିଟିସନ ଫାଇଲ କରିଛନ୍ତି
Yes.
ଆଉ ଯଦି ନୋଟିସ ଇସ୍ୟୁ ହେବ ଆପଣ ଆପିଲ କରିବେ ଡିସମିସ୍ ହେଲେ ଗଲା
No, we have a instruction to appear in this matter.
fair enough
We already filed the Wakalatnama, Mr.
Very good, very good.
Senior Advocate.
but since you have filed wakalatnama I have to entertain the writ petition
No,
I may dismiss it also please appreciate that what you are
Yes,
saying
my lord.
I thought that there is some interim prayer then that is anxiety you take your seat
Yes, ma'am.
yes
In the DB case,
interim prayer you made for interim maintenance from 24 in the CP was
No.
is filed by whom
CP was filed by the husband, opposite party,
other section
13(1)(a).
13(1)(a)
Mal-
right
That is
so you filed 24
I have
maintenance pending right
no that was filed at long last. There was not that was dismissed. The CP was allowed by judgment dated 22/2/25. I had also filed a DB case and that is pending. In that DB case, interim maintenance was initially not allowed. Then again, appellate court allowed something. Then I came before this honorable court. This honorable court passed order by the Annexure 1, page 11 on 21/2/25. Because maintenance was not paid in accordance therewith, then I filed execution case. In the execution case, the husband took a plea that he had already paid the alimony, and that order was passed in the CP by the learned Judge Family Court, Cuttack, and that is at page 19, your lordship, may kindly see.
payment of alimony is a fact
No, it is not a fact,
plea is taken
my lord.
So then, suppose now, Mr. Pujari, suppose a plea is taken. So was it substantiated by any document?
No, that is my plea. Your lordship will kindly see page 19.
No, you are not getting the question. Sir, what was the supporting material to take the plea before the court?
My plea is
Not
that,
your plea.
yes,
When the husband stated before the court that I have paid permanent alimony,
my lord.
how he supported his contention?
That is supported by the noting given by the Honorable Learned Judge Family Court in the CP after the judgment was passed on 12/3/25.
Sir, what is that?
That is what I am submitting, page 19.
You did not submit.
It has been noted. It has been noted.
पैसा मिलची पैसा ड्राफ्ट दिला कैश दिला कौन ହେଲା सेटा
ये କହିଛନ୍ତି email रे ଗୋଟେ transfer ହେଇଛି ମୋ ପାଖକୁ by email. My submission is this noting made on 12/3/25 is the learned judge family court had no authority, no competency to pass note.
Let us assume that is one that whether he had competency, but you are disputing that anything was paid.
Yes.
Okay.
Your case is that. Yes, my plea was that.
Nothing has been paid.
My plea was that 13 lakh was paid towards area interim maintenance in terms of the while complying with the direction of this honorable court in Division 738 of 24.
Sir, whatever the reason, your case is that alimony has not been paid.
My lord.
Correct.
Yes.
So that is how. So so then what happened? You take your seat. Take your seat.
No, I have just questioned
No.
tenability.
You disturb while the court is hearing. You take your seat.
No.
This order dated 12/3/25 has been passed.
So in the execution case filed in the 13,
My lord.
13 order permanent alimony execution case.
Execution case one in respect to the DV case.
DV.
So
in DV, the plea is that the amount has been paid, alimony has been paid 13.
yes.
Now you say, so when DV case, the plea is taken that alimony has been paid. So what is your reply?
I came to know that on 12/3/25 an order or a noting has been done.
That you forget that order. In legality, we are.
I am challenging that.
Sir, you challenge very well. No problem, sir. But you have to answer the court also.
Yes, my lord.
That whether the amount has been deposited in your account or not.
My submission is that is not towards.
Sir, that is a different thing, sir. That will come second.
That is.
Sir, let us not answer in circles. First of all, you are saying amount. You say that yes, amount is deposited.
Yes.
But the amount is not the alimony amount.
Yes.
So that you have to say. Let us not stop here. Yes. So then what happened?
Then this 12/3, your lordship may kindly look at page 19.
Page
This-
12.3.
My lord, this noting has been done without giving notice to the opposite party wife, without serving any copy of the said petition, and without behind the back of the petitioner, the wife, this order has been passed. So I challenged it before that honorable court that you recall this order.
Because there is nothing against you. Which part, kindly read that order.
I have read. Your
No,
lord,
sir, you may read at your chamber, but in court,
Your lordship-
which part you are agreed?
your lordship will kindly see what is the interpretation of the land.
Sir, kindly let us not again turn the page.
If it is held that
Sir, please address, you did not address, sir. You read page 19, which part you are agreed?
and the entire part recording,
Yes, sir, kindly read that.
my lord. The case record is put up today on the strength of a petition filed by the learned counsel for the petitioner. The petitioner filed an affidavit along with photocopy of deposit pay-in slip, photocopy of bank check account statement dated 10/3/2025, 11/1/2025, and 11/2/25 to 12/2/2025, and email containing transfer of rupees 13 lakhs to the account of the respondent.
Yes.
The said petition along with the documents are kept in the case record.
That's it. So court has not even said regarding anything regarding the validity or otherwise payment, the nature of payment. Because when you were saying, in fact, I was trying to understand. You have very fairly stated everything. your impression or the impression given by your client is that the court has accepted it. Court has not said anything, not a single word even. Because now how you say that the party to a litigation where there is a judge, I mean there is he's a judgment debtor. It's a money decree. He comes to court and files proof. You will say that after this order, suppose now suppose after 12/3/2025, copy has not been served. The court has not actually not said anything that copy has been served also.
Yes.
Nothing. The court has even to that extent the court is with you. This order is completely with you, not against you. Because the court doesn't say copy has been served. The court doesn't, in fact, again you can read it. Not there. That the opposite party has received the amount. And the other problem now in electronic transaction is that where suppose somebody comes here, Mr. Purohit, you would have marked. He says that I will pay. I'll go there. We are asking what we are doing. Go to the bank, state bank, transfer it. Matter is adjourn and pass over. So then what we are doing in absence of the other side, only to ensure that the person, the lady should not come and run around the court to receive it. So then he comes, files a memo giving that slip. It has happened here. Day in, day out, we are doing that only to facilitate. So suppose you are disputing it, you to take steps, no difficulty. Now, suppose now, because I cannot, suppose now, because what you have said, what you have submitted, then I have to read into this 12/3 order, so and so has received it, so and so is the decretal amount, so and so is the this amount, that amount. I cannot add those lines also.
No, I challenged it only because in the execution case, their claim was that we have paid the alimony.
Sir, the thing is that you have to catch the bull by horn. Technically, you can challenge, but still you should have taken the plea before the executing court, where you have lost the execution, that I have not received. As simple as that. That's it. And this order is rather in your favor, because something is recorded at his instance. The person cannot say, because you see, what is the best interest? Suppose you are the counsel there for the husband. For the husband, what you would insist, like the way Lordship may record, the court may record that I have received it. Nothing. Court has simply not, because he is a judge. Because the court, who has granted the decree, he deposits it. It is well within the purview of law.
No, only
Something has happened. Let me share with you. Now, many cases
that may be recorded. I have no problem. I will not pursue.
No. Because what you want, why pursuing, I am trying to understand now. Because what is my
I have no problem. I will not
am trying to understand from because what you want, why pursuing, I am trying to understand now. What you said that you have what is my
I will not
pursue understand from because what you want, why pursuing, I am trying to understand now. What you said that you have what is my I am trying to understand from what you want, why pursuing, I am trying to understand now. What you said that you have what is my I am trying to understand from what you want, pursuing, I am trying to understand. What you said that you have
order has nothing against the interest of the present petitioner. This order has nothing against the interest of the present petitioner. This order has nothing my execution case is in respect to the DB case and pursuant to the order passed by this honorable court. I am not my execution case is in respect to the DB case and pursuant to the order passed by this honorable court.
They are the issue.
I am not made any
Why you are observing this order? They are the issue.
I am not made any there is already a matter and there is there is already a matter and I have challenged everything.
Annexure 1, you let's see.
No, Mr. Demonstrator, come to the point.
Annexure 1, paid permanent
Mr. Demonstrator, come to the point. Where it says,
paid permanent
Mr. Demonstrator, come to the point. What is the execution?
paid permanent
Mr. Demonstrator, come to the point. They are taking the fee of permanent alimony has been paid. They are taking the fee of permanent alimony has been paid. That's the rule by law. Show that evidence. They are taking the fee of permanent alimony has been paid. That's the rule by law. You have not altered the law. This order does not say that they are taking I have read it 4-5 times. I requested you similar to this order does not say that this order does not say that you have received any amount. You have to show to the court. I requested you similar to this transaction. This order does not say that you have received any amount. You have to show to the court. I requested you similar to this transaction. Motive argument order falls the case. You have to show to the court. I requested you similar to this transaction. Motive argument order falls the case. My other side counsel, Naidu and Mr. Hon'Ble Minister was the government counsel. He was AC and so can you read which part the court records your acceptance of the amount, receiving the amount? Can you read from the beginning? You have to read it aloud so that you will understand. Mr. Hon'Ble Minister was the government counsel. He was AC and so that what you are reading I can because can you read which part the court records your acceptance of the amount, receiving the amount?
This record is put today on
From
the
the beginning.
strength
You
of
have to read it
the
aloud so
petition
that you
filed
will
by the
understand.
learned counsel for the petitioner. The petitioner
Mr. Hon'Ble Minister was the government counsel. He was AC and mark the date. What is the date of the government records your acceptance of the amount, receiving the amount?
This record is put today on the strength of the petition filed by the learned counsel for the petitioner.
They are not saying that Mr. Hon'Ble Minister was the government counsel. He was AC and
The petitioner filed an affidavit along with the photocopy of
your acceptance of the amount, receiving the amount.
today on the photocopy of petition by the learned counsel for the petitioner.
They are not saying that Mr. Hon'Ble Minister was the government counsel.
11/1/2025 and the petitioner filed an affidavit to along with the 12/2025 and email containing transfer of your bank by the learned counsel for the petitioner.
They are not saying that Mr. Hon'Ble Minister was the government counsel.
11/1/2025 and the petitioner filed an affidavit
Problem is that
to along with the 12/2025 and email containing transfer of your bank by the learned counsel for the petitioner. 10/3/2025
this order, the court has a bounden duty to accept everything before it. Court cannot say that appointed a member can go there. You should take advantage of this order. So now the court has a bounden, they are saying accept where they are saying Now the question is, where they are which has been whether the busy payment, one payment amount because of busy matter it has come to me. Now suppose you say that 20 order 25, 25 order they are not saying what is they have deposited in the court. Consider that order. That is why I was telling you the best case scenario. I suggested this 20, 25 order. What they are doing because now suppose you say disposal of the 53 order non-contest state 25 order they are not saying what is only a signing of that as asserted by the person. That is very clear. The court is very clear. I was telling you now the best case scenario. I suggested that is how the judges are now proceeding. Now suppose you say disposal of the 53 if contest you say that you have the receipt and say state and file that as only a signing of that as asserted by the person. Anything, any comment from this court because there is a possibility that is how the file take it out as the Athena court is something will come up against you. If contest you say that you have the receipt against you not signing of that as you give the chance of anything, any comment from this court as this order. Because I cannot also may have because if you give my matter I will not pass anywhere. Something will come up and what you are saying is the statement of fact on behalf of the petitioner against you not. And suppose you are saying that this change is the reporting the chance of amount not with the amount of because I cannot say this is that and other that we don't deal with the factual aspect. So what you are saying will agree by that then you come up in that. And suppose you are standing in case of this is the reporting the chance of amount not with the amount of because I cannot say there is a very
I can file this
this discussion regarding legal advice is free and going to that side. That is my job. Are you the party in this case?
I can file this
because when your thought process becomes sounded legal advice, when you do the emotion, you go to that side. That is always around. Because you are you the party in this case? I am not saying you are the party. I am reporting your law. Your imaginations cannot say that the law order is bad. If they are taking your way, you say that they are not received. I am not saying you are the party. I am reporting your law. And suppose any order is your imaginations cannot say that the law order is bad. You challenge that. If they are taking your way, you say that the bad facts are designated. And suppose any order is your imaginations cannot say that the law order is bad. You challenge it. If they are taking your way, you say that the bad what order is passed by a judge. And suppose any order is your imaginations cannot say that the law order is bad. You challenge it. If they are taking your way, you say that
not mentioned anywhere that it is
passed by a judge. And suppose any order is your imaginations cannot say that the law order is bad. What the alimony is become.
saying that
Passed by a judge has to be validated. Your imaginations can the same as the way you are saying the nature of the judge saying that it is donation. I can suppose let us ask him. I have the power. Can you say that my donation has to be validated? Your imaginations can the same as the way you are saying the nature of the judge saying they are 24 or 25. Can you say I can suppose let us ask him. I have the power. Be careful in actually your imaginations can the same as the way you are saying anything else. I think you are arguing something. Madam, I think the problem is that in case matter, what I imaginative apprehensions are there. I think you are arguing something. Madam, I think the problem is that in case matter, what I imaginative apprehensions are there. Now I will ask you a question. You have to answer it. Straightforward. Binary answer yes or no. In this petition, I have stated that you have not received those amounts. Now I will ask you. I did not want to ask you because you are saying about the binary answer yes or no. The court in this you have not received the amount. You have not received those amounts. Those receipts are false. Now I will ask you. I did not want to ask you because you are saying about no. Binary answer yes or no. The court no, not whatever. Those receipts are false. Now you are telling me yes. Binary answer yes or no. Look at the order you are seeking. You are seeking a not whatever. Recall of the order which letters are had you are not the first. In this position where you are seeking recall of the order, where have you stated that the receipts are false had you are not the amount has not been transferred. In this position where you are seeking
passed behind my back.
please don't argue, please don't because I the receipts are the amount has not been charged to the court by please be clear in your mind. Where in your petition was stated that you have not received the amount has not been charged to the and immediately strike down that one. Be clear in your mind. You don't have to search for it because you are the petitioner. You have not received the amount has not been charged. If I could have asked, strike down that one. But this little bit of experience cannot be added to the petition. You are the petitioner. The way you are discussing it and the problem when I asked for the first time, if I could have asked, I got it. Whatever facts have been stated, if you are disputing that, you have to straight away swear affidavit and file before the court. No court, much less the judge family court, will entertain this kind of activity by any person. Suppose he has not paid you. He produces a false affidavit. Where is your petition before the trial court?
Annexure 3, let's see.
I'm there at Annexure 3. So what is your statement? Para 4, you are referring which provision in CPC? There is no provision.
Without hearing me, how can the learned judge family court pass an order?
Have you read the order?
Yes.
The decretal court will ask the
Petition. They have filed a petition.
Madam, you are not listening and answering. A court passing a decree has to invite the decree holder to for recording for deposit of money. Which provision? This cannot be like movie. Common parlance discussions are not legally tenable. Who gave you this idea that for satisfying a decree, permission of the decree holder is necessary?
But a petition has filed.
You are not getting answering the question. Don't ask me. Petition is filed by telling 10 times petition has been filed.
But after passing
You must read the order. For satisfaction of a decree, somebody goes to the court. The decree holder has to be informed.
When a petition has filed,
Have you examined any law on this? This on the contrary, the court passing the decree has a bounden duty to accept that. It doesn't have an option. That is how even 25 years after, the money still lies before the trial court. After 25 years, one division bench of this court has passed orders. The money should have been invested. There is no mechanism of accepting other than accepting the money. The money goes to a civil deposit.
सीपीए से जो जजमेंट पास हैला सेथिरे कोर्ट
ଆପଣ analyze କରିକି ଶୁଣନ୍ତୁ, ଆପଣ ଗୋଟେ ଆପଣ you cannot narrate a story like
narrating
so which provision you relying on that the decree order because this is serious law legal question.
simple thing.
The court passing the decree has to inform the decree holder for deposit of the decretal dues. Which provisions? So don't mix up. You should keep away from these legal propositions when you are yourself involved, because the 4 is a misstatement of law on record. Now, where you have stated that you have not received the money.
In my petition and in Annexure 3, I have clearly mentioned
No,
that.
please answer because it is recorded. You can now I'll pass a order. If you have stated, I'm asking you because you have not stated, but still, because asking that who ate the apple, you have not stated. You have not received the money at the statement. The petition is incorrect.
In my petition, I have mentioned.
Yes, where you have stated. By reading and rereading.
Petition.
Yes, where you have stated before the court that you have not received.
Para 14, you will not say.
Read it. Para 14 in the petition. Which page?
No amount had been paid towards alimony. It is there.
No, don't evade the question. Question is very straight. Which paragraph you are reading?
Present petition, my
Which
lord.
page, madam?
Page 5, para 14. Page 5, para 14.
କୋଉଠିରେ ସେଟା କୋଉ ପିଟିସନ ରେ ଅଛି କୋଉ ପେଜ ରେ ଆପଣ
Petition.
ପ୍ରେଜେଣ୍ଟ ପିଟିସନ ର ପେଜ 5 ନୁହଁ ଆପଣ ତାହେଲେ କ୍ୱେଶ୍ଚନ ଆଭଏଡ କରୁଛନ୍ତି ନା ବୁଝି ପାରୁନାହାନ୍ତି ଆପଣ ଯୋଉ ପିଟିସନ ଫାଇଲ କଲେ ଟ୍ରାଏଲ କୋର୍ଟ ରେ ସେଟା ଦେଖନ୍ତୁ କଣ କରୁଛନ୍ତି ଆପଣ ମେକିଂ ଏ ମାନେ ଫନ୍ ଅଫ ଏ ପ୍ରୋସିଡିଂ ସେତେବେଳେ ମୁଁ ବୁଝୁଛି ଆପଣ କହୁଛନ୍ତି ଯେ ମୁଁ ଲେଖିଛି ଆପଣ ପିଟିସନ ରେ କୋଉଠି କହିଲେ ପଇସା ପାଇନାହାନ୍ତି ବୋଲି
Present rate petition.
No, before the trial court. You cannot turn around now. So what I'm asking you, you can see I've been very clear in my question. Order 21 तक पढ़ दीजिए अपन बेटा तक ट्रेन करेगा कथा एटलीस्ट सी विल लर्न समथिंग सिविल सीपीसी रे दियो ठीक है सेटा कोन खुलचुंदी ଆପଣଙ୍କ ପିଟିସନ ଟା ପଢନ୍ତୁ କୋଉଠି କହିଲେ I told you I did not want to ask you this question to embarrass you. You have not stated. And since you have stated so far, just to meet its logical conclusion, you are attributing something to the court also without any basis. You are attributing to the other side without any basis. Now I'm asking you this. I'll record now. Whether you have received those amount and transferred or not.
I have received.
Correct. Leave it there. This is not a good thing to do. But CP Shredyan. Who? I'll read it aloud. Madam, you have to participate in the court proceeding. What is this? I'll be asking and waiting for you.
No suit shall lie. Challenge.
कौन पढ़ुଛନ୍ତି ଆପଣ?
21.
Order 21 ରେ କଣ ଅଛି?
Objection to the jurisdiction.
କହି ଦିଅନ୍ତୁ ମତେ। ମୁଁ କାଢି ଦେବି। କୋଉ ପେଜ ଟା କାଢି ପଢୁଛନ୍ତି ଦିଅନ୍ତୁ ମତେ so that I will understand what you are reading also.
Order 21, data କୋଉଠି order 21, section 21.
କୋଉଠି ପଢିଥିଲେ law କୋଉଠି ପଢିଲେ?
ଆगे ଇଏଟା
Modes of paying money. Modes of paying money.
No, ପୁରାଟା ପଢିବ ସବୁବେଳେ.
Again.
Execution of decree and orders.
Orders, payment under
of
decree.
payment under decree.
Decree.
ସେଟା most crucial. ହଁ କାଇଁ ତାପରେ ପଢନ୍ତୁ.
Modes of paying money under decree. All money payable under a decree shall be paid as follows. Namely, by deposit into the court whose duty it is to execute the decree or send to that court by postal money order or through a bank or out of court to the decree
So,
holder.
you see, when I told you from the first principle. It is not that I was looking at, because I was discussing with you. I cannot put the burden of you, but to see the language. What I said is absolutely on dot on the point. But deposit into the court whose duty it is to execute. But what you have written in paragraph 4 of your petition, that there is no provision of law for passing such an order.
So,
But order 21, so when upon sit में CPC पाओ भी ना ठीक है. CPC is a very elaborate, and you require patience to understand the law also.
so 583 जे माने जगह 483 टा काट दे.
नहीं अपन जदि 21 को ताले पारा 4 रे कोन लिखचंती अपन पारा 4 पढिले पिटिशन रो अपन को जोटा 22 पृष्ठ रे बाईस पृष्ठ रे पारा 4 रे कोन लिखले और again पढिबेनी सेकेंड
That the above said order has been passed
पारा
behind
4
that there is no provision.
नहीं से पेज पढ़ी सर पेज तक
page
इस पृष्ठ रे पारा 4 पढंतु
That there is no provision in law for passing such an order.
हां पारा 3 पढिले कोड अपन लिखुचंदी
That after passing of the judgment and decree, the court becomes functus officio.
हां
And so such an order as has been passed on 12/3/2025 could not have been passed.
So they'll write on the face of order 21. Then who will execute? Can the High Court execute a decree passed by a civil court? You should have examined the law, because you are acting as your own counsel. Then kindly read B.
That there is no provision in law for passing. Para 4.
पारा 4 आपनकर जोटा पारा 3 तो पढ़िले दैट इज नॉट 4 तो आपनकर गोटे स्वीपिंग स्टेटमेंट देले बट आपन तो हाउ यू आर रिकंसिलिंग विथ ऑर्डर 21 रूल 1 Yes, Mr. Mishra, you have anything to say? Your lauded juniors are so anxious not to. So I didn't know actually. I didn't know that I will go this far in hearing, and whether I will be able to issue notice. I was telling she doesn't realize, because whether I will be able to issue notice or not, that I do not know.
And they should have been silent till your lordship decides a thing. But in any
No. They were so that is why I'm asking you, because I did not ask you, because anything to say on this or order 21 on passing of the order.
In fact, I was little disturbed to see such a petition, which I was pointing out to your lordship. There is a family court.
Take your seat.
There is a family court decree.
No, regarding this, let us not go to other places.
2, 3.
Yes.
Now, that has been challenged in appeal. I have a copy of the appeal.
Mr. Purohit has, or Madam has said that it is in appeal. MAT is pending.
MAT
And the decree and everything has been pending. Maybe I am because I have some. Because I was sitting and issued notice.
Sethi kahile bhi AD ground tare. This appeal memo runs up to 65 pages. 65 pages. Yeah. Yes. ସେଠି ଗୋଟେ ପାରା ଗ୍ରାଉଣ୍ଡ ଏଡିରେ କହିଲେ ବି ଯେ 13 lakhs ଟା କମ ହେଇଯାଇଛି। ବ୍ୟାଙ୍କରେ ଯେତେବେଳେ 10 lakhs ରୁ ଅଧିକ ଟ୍ରାନ୍ସଫର ହୁଏ ସେମାନେ କହନ୍ତି ହ୍ୱାଟ ଫର ୟୁ ଆର୍ ଟ୍ରାନ୍ସଫରିଂ, वी have written we are transferring it for permanent alimony, and we send an email also saying that we have satisfied the decree by paying that 13 lakhs. Whether it will be enhanced, whether the divorce will be confirmed or not, will be a different issue so far as the matter is concerned.
In fact, when maybe you were present or not, I have gone to the extent of that they can file a 24 in MT also.
But that is true. Not only that, they could have very well raised this point because he has accepted it. 13 lakhs.
No,
Arrear was never 13 lakhs.
Mr. Mishra, I have, let us not embarrass further because I have pointedly asked this question which I did not ask. That where you have stated that you have not received the money, told the court at least.
And my lord, DV case, 125 case.
Let us leave it there. So this petition is now not, it will not.
So nothing.
Yes, Mr.
I think the petition.
I will observe this.
Only one line.
One second. So Mr. Mishra has nothing to say now. Apart from, I'm giving a background. Mr. Purohit, I'll pass an order on, I'll record everything on merit because that becomes a contentious issue. But you want to withdraw, I'll pass an order of dismissal in view of order 21. But I'll give the reason, all the deliberation. We have spent so much of time because otherwise the issue will never attain finality. These facts that
And one
the
thing I will
order
point
is
out.
passed.
My
The
DV
challenge,
case,
but
my
in the
lord,
petition, it has not been disclosed that she has not received the money or the receipts are false, email is false. Any kind of allegation could possibly. That is not there also. And how this court will, there is nothing in that order which contrary to 21, order 21, rule 1A.
DV matter टा भी Hon'Ble Supreme Court को जाइए चट्टी it was referred for conciliation. चट्टी भी 13 lakhs alimony दिया है चुवेल भी discussion ला. Conciliation failed, that's a different thing, my lord. And the DV case is, I think.
Mr. Actually, what would be the plea in the CP because CP is put into now appeal. CP is not put to execution. That we have discussed. Mr. Pujari, when I asked him that whether you have put to execution, in which execution this plea has been taken. Then it is only DV execution this plea has been taken, and what is your rejoinder to that? In DV execution, the husband says that I have deposited this amount. Now, whether you have filed any rejoinder, these are the discussions we have already said. Substantial, almost
And
an hour.
had it been in my domain also to arrive at a amicable things, I could have done that. But I think it is not in my domain.
No, since MT is pending before the appellate court, it is the best forum.
Only thing
Because I cannot observe anything regarding the appeal or the CP.
Here, even in appeal. So, but I don't think it is in my
Let
domain.
us see. The time is a great thing. Time is a great factor. Time is a great factor. It will heal many things. It will change many things. Yes, Mr. Purohit. There is nothing. The basic pleading before the Lord at trial court regarding non-acceptance or the deposit being falsely stated, that much is not there also. And functus officio is a word, it is more used in administrative law. Suppose a recall of a decree or say the para 4, or anyway, that's the language used. So in fact, the court has a bounden duty to accept that. Court cannot refuse.
Our only ground was that without hearing us or without serving a copy on.
So I asked you that you accept that petition and whatever you do, that's a different thing. That is how that the court has to. In fact, I was more clear. My only question to you is that why under law that the court will ask the judgment debtor.
No, something.
No, because he has not read. That's again he is struggling. Read 2. Order 21, rule 2.
Yes, sir.
Rule 2 says give notice thereof.
Hmm?
Rule 2
Yes.
says where any payment is made under clause A or clause C of several 1, the judgment debtor shall give notice thereof
Yes.
to the decree holder.
Decree holder. Directly or by registered post, acknowledgement due. So that is enough. Now they can send it also. But you are saying that we are not given no opportunity.
Yes.
So 2 is against you. First of all, the law is very, the order 21 is very clear that court has to accept it. Duty. The language used is duty, very unusual language. By deposit into the court whose duty it is to execute the decree.
Mallard.
That much. That has been done. And after execution, either through the court will send or so now they will send it. So at best, what can be said? Now they will send it. The problem is now that you are because that will be a contradictory order in the facts. Because now, interestingly, maybe you could have taken that plea. You have now challenged that order. So how it will say that you are not aware of this? The reason is obvious, Mr. Abra. Like in this case, after receiving the money, still she challenges it. But the money can be parked with the court. Madam, you sit down. Don't disturb your senior. You are spoiling your entire case. Actually, the spoil has been like already spoiled, and you are sitting chopping up the branch where you are sitting. She should not have accepted the money. Suppose he wants to challenge her enhancement.
That was given to the account. There is no question of not.
Correct. So now, so that was not earlier. Now kindly see through bank. Three. Order 21, Rule 3. Where money is paid by postal money order or through a bank under clause A or clause B of sub-rule 1, the money order of payment through bank, as the case may be, shall accurately state the following particulars, namely, number of the original suit, what Mr. Misra was saying, names of the parties where there are more than 2 plaintiffs, there is only 1 plaintiff and 2 defendants. How the money remitted is to be adjusted, not applicable. Number of the execution case of the court where such case is pending. Name of the address of the payer.
That is what my submission is that
So where you find
unless an execution case is filed, my submission would be he should not have recorded this.
No.
Unless an execution case is filed.
Then you are also not reading the 1A. Shall by deposit into court. Then
Execute the decree.
Correct. Duty to execute. So court cannot refuse. And if you want notice, though it will be unnecessary because now you are aware of that. So they will send this to that who have deposited this money to you. How does it help you?
No, they have all since in the other case they have already submitted it. There is no question.
And more so before Supreme Court and NMT, you have said that 30 lakhs has been deposited. It is not adequate.
No, I have not said. No. I have never said that I have not received the money. What my submission?
Unless, if you want setting aside of that order, court accepting the decretal dues, stating that, and interestingly, the court has not said anything regarding you receiving the money also. Court had simply recorded the facts, nothing about you actually.
Because they took the ground that they have paid.
Mr. Pujari, if you want 30 lakhs, you claim enhancement. If you want 1 crore, you claim enhancement. If you do not want anything, just register it. Because in many cases, alimony is not accepted, it put to register grant of decree of divorce. Alimony can be accepted conditional, or in terms of the appeal, one can receive 24. And this approach of not reading law, going by emotion and only common sense logic doesn't happen. It fails. I cannot apply my common sense to the strict procedural law. This is not the money there. This is not money here. You have to go case by case. If you are resisting the execution, taking a plea that I have not received in DV, file that statement. Let it be tested by the court, before the court rather.
Yes, I have filed objection there.
Oh, yes, whatever. So let the court pass order, whatever happening, and there is a MATA also. MATA, you can say that you want more money. That's a different thing.
No,
But
no,
why-
money is not in the question. Question is whether that is regarding permanent alimony or not, or regarding entry maintenance.
So you take that plea that I'm before the appellate court. You can take that plea before the appellate court. But this order is,
No, that
order.
will be decided in the DB case.
Who has challenged in appeal?
I have challenged in the
Exactly. So now, Mr. Purohit, while deciding the appeal, the court will not look at court will not ask Mr. Misra's client that what about the alimony? That's the first thing the court does.
No, there is no question of that. It will be the executing.
That is the only question there.
No, the executing.
Before the MATA court, division bench asked this first question: what is the decree? What is the amount of alimony?
No.
How much has been paid to the husband, not you?
My cause of action started from the DB execution case, because DB execution case.
You take that, please, sir.
That is what I am submitting.
So you take that, please, sir. How can I direct that the court's recording that he has submitted when you yourself are not disputing it in your petition? Madam was avoiding to read that.
No, we are disputing that it is not regarding permanent alimony. It is regarding.
Sir, you filed that in case of execution. But then I have to again tell you in CP the money has not been deposited. You are saying.
Since there is a stay, in this case, there is no question of my filing an execution case in the CP.
Sir, you are not getting it, sir. Whether you file or not, that's not important.
My cause.
Kindly listen, then you will understand. He has also prompted you to go off track. In CP, you are disputing the satisfaction of the decree, permanent alimony, or you are not, or you are approved that.
At the present stage, that has not come into picture.
Correct. So you leave it there. So whenever a question of permanent alimony comes before the appellate court in MATA, or you file an execution, that will be addressed by the court. In DV, the plea is that we have paid 13 lakhs. So if you have not received, you say that I have not received anything. You give the calculation.
No. There is no question of not receiving. The question is the executing.
Let us leave it there. Enough, Mr. We are not going anywhere. And the petition is reckless. Doesn't refer to Order 21. If Order 21 is violated, then you file that application before the court that it is not as per 21. And that is how it is even said that where any payment is made, the decree or the judgment debtor will issue notice thereof to the judgment, not even the prior notice. That will be an intimation regarding the payment. And now you are well aware of that. It is a useless formality now that will inform you that so and so amount is deposited. By saying so many things, the deposit cannot be changed that it has not been paid. Now, what heading? It is DV Act, this is area, this is this is that. So that is a different thing.
The only question on the basis of which I have challenged that 12.3.25 noting is that no copy was sought on me. Neither.
What is the legal duty? What is the legal duty?
No notice was given to me.
Where is that? The statute says after deposit we will be informed. We have read it now just. Slick hand. Mr. Basudev Pujari for the petitioner and the petitioner in person. Yes, I'll dictate the order. I'll take some time to dictate the order.
Madam.
Yes. The petition has been filed with the following prayer.
Your Lordship is recording our presence?
I'll definitely. You have appeared on which date?
Today we have filed. Today we have filed. Today we have filed. Today we have filed. But yesterday,
Mr. Samir Misra, senior advocate, along with Miss ଆପଣଙ୍କ ନାଁଟା
B Patti.
Vishwarupa Patti.
ବିଶ୍ୱରୂପା ପତି and the other vociferous counsel?
Palta Singh.
Acha, Palta Singh. Yes, Palta Singh. For the opposite parties. Para. With the following prayer.
Lord Sima, kindly grant me 2 minutes.
She should not use your band and gown.
My lord, my lord.
Because we are being watched that arguing on cause what she is saying? Dorkar quote koriya ta. Ordering portion ta ordering portion ta what is why it is requires execution jana paribon.
ଆଜ୍ଞା ଏଇଟା ଏତେ ବଡ ହେଇଯାଇଛି ଏ ବ୍ରିଫଟା
ବୋଲେ ଆଉ କୋଉଠି କୋର୍ଟ ହେଇଛି
ଆଜ୍ଞା ଏଇଠି ଅଛି ମୁଁ ଦେଇଦେବି ସାଙ୍ଗେ ସାଙ୍ଗେ
ତାହେଲେ ଜଜମେଣ୍ଟ ର ଅର୍ଡରିଂ ପୋର୍ସନ ଟା କୋର୍ଟ କରିଦିଅ
ଏଠି
the direction portion of the judgment is
ସଭା ତଳ ପାରାଗ୍ରାଫ ଟା ଅଛି ଫାଷ୍ଟ
ପରେ ନେଇଯିବେ is reproduced herein from the photocopy as produced by the learned senior by the learned distracting counsel appearing for the
opposite party
281 page रे अछि civil proceeding is partly allowed contest and respondent but without cost resolved तापरे up to गला सेटा हां then the court order XXI पूरा order XXI execution of decrees and orders order टा कोर्ट कले CPC रो ता पूर्व लिखिबे for execution of decrees and orders. The order 21 of the CPC, deals with execution of decrees and orders. And is reproduced here. 1A, B, C, 2.
Yes.
Hello. 4, 5. प्रोवाइजोटा भी देखी दियंतु एबे सिंस प्रोवाइजोटा भी देखिबे जे व्हाट कोनटी प्रोवाइजो देखले आपण जोटा म कहउथिली सेटा अगेन एम्प्लीफाइड इन प्रोवाइजो एते मोटा मोटा भाई को खोलिया के कष्ट
एटा नुवा जीएस राम को भाई
जीएस राम तो से इलाबोरेट लिखंदी खाली बैरा खिले धरिया के सुविधा एटा ने परे फेरे देली खोली देले ऑफिस रे कोने रेडी खोली के रखि देंदु
मो कोडे फोटोकॉपी करी सांग सांग कोर्ट मास्टर को दे देबी
हां
लॉन्च होची आगे
provided that where the decree holder refuses to accept the postal money order or payment through a bank, interest shall cease to run from the date on which the money was tendered to him, or where he avoids acceptance of the postal money order or payment through bank, interest shall cease to run from the date which money would have been tendered to him in the ordinary course of business of postal authorities. So it is a unilateral act actually. कोट कर देना ना प्रोवाइजर कोट कर देना the petition before the learned trial court raises it forms in CMA 128 of 2025 has been annexed to the petition marked as Annexure 3. The said petition paragraphs are reproduced herein, scanned and reproduced herein. 1 to 9 reproduce कर देना है ना It is apparent from the averments made in the petition that the present petitioner, who was the defendant before the learned court, family court, and also the decree holder.
Your Lord, may I interfere, my Lord? Lord, may I kindly see page 23 of my brief?
Yes. I quoted that.
No, Ochi para 9-8 ta.
Yes.
This petitioner wife is not making a comment at this stage on the alleged petition referred to in the order dated so and so, because this petition is filed for recalling the order.
You should not have.
No, because I have not.
You have to come to the court in clean hands.
I have not given the merits.
You should not have. The court, because the judgment is passed in 24th, 11-24 रे, November 24 रे judgment pass ହେଲା. March 25 रे पैसा deposit ହେଲା.
November 22-25.
ए?
22-25.
ठीक ଅଛି, order ସେଟା ପରସେଣ୍ଟ ମତେ ଦେବେ ତାହେଲେ ପୁରା ଜେରକ୍ସ କରି ଦେବେ
ସ୍କାନ ପୁରା ଜଜମେଣ୍ଟ ଟା
ଫାଷ୍ଟ ପେଜଟା ବି ଦେବେ ମୁଁ ଡେଟଟା ମତେ ଭୁଲ ଲେଟ୍ ଡାକିଥିଲି
ଆଜ୍ଞା ମୁଁ
କାରଣ ମୁଁ ଯୋଉଟା ଡାକୁଛି ମୁଁ ଅନ୍ୟ କି ସେଟା ସେଇଥିରୁ କହୁଛି ହେଇଥିବ ସୋ 3-25 ରେ ସେମାନେ ଡିପୋଜିଟ୍ କଲେ
More only thing that I wanted to submit is that I have not submitted on the merits regarding the order dated so and so because I did not have the copy.
you cannot hide it
No, I did not have the copy. What is
sir
the question?
copy there is no ସେଥିପାଇଁ ତ ସେଥିପାଇଁ order 20 ସେଥିପାଇଁ
Not
order
the question
21
of hiding because
order 21 ଟା in a disposed of matter order 21 does not mandate service of copy so the mechanism is reverse deposit କଲା ପରେ ଆପଣଙ୍କୁ ଜଣେଇବେ that's it
ମୁଁ ସେ କଥା କହୁ ନାହିଁ ଏ ଯୋଉ 8-3-25 ର ପିଟିସନ
ଆପଣଙ୍କର confusion କଣ ହେଲା because she not a she has not read law seriously she is studying law for her own purpose of taking up her own matter so she doesn't understand what she is arguing ଆପଣ ପିଟିସନ ଏଟା କାଇଁ ଲେଖିଥିଲେ ଆପଣ ପିଟିସନ ଫାଇଲ କରିବା ଦରକାର କଣ ଥିଲା ଯେ ଆପଣ ତ then you have become aware of the order now you have to challenge the order on merits
Yes.
so everything is perfect
No, once order was given before the learned DB court.
sir which provision sir in a disposal of matter for depositing of the decretal dues you have to be intimated সেটা কোটি আছে that is your fulcrum of your argument
A petition.
এটা তো administrative action নয় principle of natural justice it is guided by CPC order 21 rule 1 ABC proviso also proviso দেখুন সেটা I pointed you that even you can refuse still the court will not hesitate to accept that that's it
No, now
let us please enough of argument and let us not spend time now wasting we're already consuming time for no effective order has not disputed the facts as observed in the order dated 12/3/2025 that the payslip, photocopy of the bank check, account statement, jaha achi pura likhi debe page 19 re starting with photocopy of the deposit up to neki to the account of the respondent. The only plea taken in the before the learned trial court is that the judgment debtor, petitioner in the CP, as far as payment of alimony is concerned, has not served copy of the petition on the other side. Reading of order 21 as quoted above makes it amply clear that there is no such mandate after disposal of the proceeding. Rather, order 21, rule 1 into bracket 2 makes it amply clear that where any payment is made under clause A or clause C, clause A rather, the judgment debtor shall give notice thereof to the decree holder, either through the court or directly to him by registered post. In considered view of this court, the learned judge family court, being the executing court, does not have an option for refusing to accept payment of money, payment of proof of money, as indicated in its order, dated 12/3/2025. Therefore, the order is just and proper. in accordance with the provisions of CPC, particularly Order 21 that provides for execution of decrees and orders. The petitioner being present in person was also asked whether she disputes the bank transaction from a bank receipts, check, taking a fair stand. No, she not taking a fair stand. She, on being repeatedly asked, she submits that she does not dispute the said bank transactions or the receipts. Apparently, it can be seen that she had never disputed the said transaction or the receipts before the trial court while filing the application CMA number 128 of 2025. A plea is taken. Before the learned trial court, as has been reproduced above in the petition. The plea is taken in the petition before the trial court, as reproduced above. So when that plea is not taken, you have taken a new plea in the writ court before this court. Before the trial court, you have not said that money I have received towards so and so, so and so. There is no statement.
Statement in the main petition.
Before the trial court, you have not stated.
Trial court, I have stated that on merit, I am not speaking anything because copy has not been served.
The point is, what was that arrear maintenance interim which he wanted?
That just now I have said.
It's very
Just now, because now it is experience of Mr. Purohit that is working. Now he says that since I have not said anything regarding the context. Now you could have said.
and
My lord, your lordship, kindly please.
No, please don't disturb. Nothing new you can argue, sir. Already everything has been covered extensively.
I have not taken any new ground in the petition.
Sir, nothing now you can be argued now, I'm saying. So I was trying to ensure that if you have stated anything, whether that is being dealt. You have not stated regarding, you say that para 8.
Yes.
Correct. Above in paragraph 8. That the petitioner, quote, the petitioner wife is not making a comment at this stage, quotes. Regarding deposit of the amount before the Lord Judge Family Court in the disposed of CP number so and so. A new plea has been taken in the writ application before this court. But सेटा भी रीड रे भी कोडी नहीं ना अपन से अमाउंट कौन पे रिसीव करछन व्हाट इज योर स्टार मिस्टर पुजारी वन फाइनल वर्ड
Arrear maintenance.
कोर्ट लेक्चर
First in a DB case.
कोर्ट लेक्चर
retrelection.
को पैराग्राफ
Paragraph 14 would. Retrelection, but that is hard to fathom. Paragraph 14, page 5. That
पूरा पूरी पचारे
again.
ମୁଁ ପୁରାଟା ପଢିକି ପଚାରେ 14 ରେ ଲେଖା ହେଇନି ସେଇଟା when I ask a question after I go through the entire proceedings I ask that
Right.
14 ରେ ସେଇଟା ଲେଖା ହେଇନି
Wife immediately on being served a copy of the petition in DV education filed her objection stating that 13 lakhs has been paid towards interim arrear maintenance. DV case re कहले. Not this amount is married. No amount has
this
been
is
paid.
going in
towards-
circles we are discussing the CP
Married.
the writ petition challenging order in CP CP ରେ ଆପଣ କୋଉଠି କହିଲେ ଯେ ସେ ଟଙ୍କାଟା ମୁଁ ପାଇଲି ବିକଜ ରାଦର କହିପାରିବେ ଯେ ମୁଁ CP ରେ ଟଙ୍କା ପାଇଛି DV ରେ ପାଇନି ଠିକ ଅଛି
Exactly.
ପସିବଲି
Now she is aware that CP ରେ ଦିଆ ହେଇଛି.
ସେଟା ବି ଲେଖା ହେଇନି ଇନଫ୍ୟାକ୍ଟ it was argued in that manner ଯେ ମୁଁ ପାଇଛି ଟଙ୍କାଟା ସେଥିପାଇଁ but ସେଟା ବି clearly ଲେଖା ହେଇନି the problem is that unless you write that clearly in the petition also that can't be recollected
ସେଇଟା it is very difficult to accept that ମୁଁ DV case ପାଇଁ DV ତ execution case pending ଅଛି ଯାଇ Supreme Court ରେ pending ଅଛି.
ସେଟା ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ଆପଣ CP ରେ ବି ଚ୍ୟାଲେଞ୍ଜ
Yes.
କଣ ହେଲା no a new plea is orally submitted before this court by the learned counsel for the petitioner ନା ସେ ନିଜେ କହିଲେ ନା ଆପଣ କହିଲେ ଯେ ସେ ଟଙ୍କାଟା ଆପଣ ସେଥିପାଇଁ ପାଇଛନ୍ତି ବୋଲି
ମୁଁ ତ ମୋର ନେଇଛି ଗ୍ରାଉଣ୍ଡ ନେଇଛି
ନାଇଁ ଗ୍ରାଉଣ୍ଡ ନାହିଁ ସେଟା
ଏ ପରେ paragraph 14 ରେ very clear.
ଆପଣ paragraph 14 till ଦିଟା ଯାଏ ପଢନ୍ତୁ I have read so my understanding you have not stated anything read slowly
Filed an objection on 36/25 stating that rupees 13 lakhs had been paid towards
objection file କଲେ ଆପଣ
and in the CP case there is no interim maintenance.
ଆପଣଙ୍କର କୋଉଠି ସେ objection file କରିଛନ୍ତି which case
In the DV execution case.
so exactly so I have understood it correctly we are now discussing the court the amount of money deposited in the court in CP
Not written, sir, not in CP.
I mean, see the amount deposited and the evidence produced before the CP. ଆପଣ ସେଟା କହିବା ଆଜ୍ଞା ଏଟା ମୋ ପଇସା ନୁହଁ ସେଟା ସେ ପଇସା that's a different thing.
Nowhere have I stated.
Mr. Pujari, read again 14 slowly. Then you will understand what I am saying.
No amount has been paid towards alimony.
ଆପଣ ଏଟା DV ରେ ଦେଖନ୍ତୁ ଆପଣ ଲେଖିଛନ୍ତି DV not in CP. I am asking you
CP
ଆପଣ CP ରେ ଯଦି question ନାହିଁ ତ ନାହିଁ ଠିକ ଅଛି
CP that question has not come.
ତ କଣ ଲେଖିଲେ
I am concerned only because of orders passed in DV.
It has been taken in the paragraph 14 of the petition which is reproduced herein. Upon going through the paragraph 14 of the writ petition, nothing turns on the averments made in paragraph 14. Inasmuch as paragraph 14 refers to the DV execution case number 141 of 2025, which arises out of the execution case, which arises out of the DV case, not the CP number 488 of 2018, disposed of on 12/3/2025. अपन सेटा देबे कारण जेतु 9 डेट पेट भूल हे जो पे
नहीं सेटा सब
ठीक अछि
yes after the proceedings is over.
So in fact some more additions and reasoning will be there but this is the order.
Right.
Yes. अच्छा आपण मेमो फाइल को विड्रॉल पाई
withdrawal ପାଇଁ କଣ memo start କରୁଛି
मेरिट ହେଲା କାଇଁ withdrawal କାଇଁ ଦବା
नहीं मु ऑब्जर्व किसी करबी
ଆପଣ ତ ଡାକୁଛନ୍ତି merit
सेटा डाके पर्पस अछि नले मु केति देखिबी जे मु गोटे आई एम लाइव अपीयरिंग इन कोर्ट सेतरे गोटे घंटा परे आई विल अलाउ विड्रॉल ऑफ द पिटिशन को गोटे घंटा तो नो एटा 1.5 घंटा पर मस्ट अंडरस्टैंड ट्रांसपेरेंसी हैज इट्स ओन
बहुत के केस एक्चुअली जेता
petitioner being present in court herself files memo for withdrawing the application. Accordingly, the petition is disposed of as withdrawn.
ना से पिटिशनर का लेके काउंसिल लिखो
No. Sir, these are all preserved. These are all preserved.
नहीं काउंसिल लिखो
See, नीचे साइन करिए
Sorry to mention.
Pujari,
Recording in progress.
in that case, Supreme Court has directed for payment of fine of 10,000 each for the husband and the wife who filed 44 cases against each other. Operative portion that I did not mark. I told it's not your case, but I'm just sharing it with you. Neha versus Abhishek, Neha Lal versus Abhishek Kumar. Research Associate has put it. 20th January 26, stayed together for 65 days. Litigation for more than a decade. 40 to 44 litigations. Both parties penalized with rupees 10,000 cash each.
You will exchange between themselves.
But what about the chambers? These 44 cases were, it is either in your chamber or my chamber. Or Mr. Mohanty, now I cannot say. Mr. Mohanty 22, you 22. Mr. Mohanty also, maybe at least 10 cases is good enough. Huh. The 10,000 cash part is also interesting. You have got it. Okay, thank you. So it is another Neha. Rajneesh versus Neha. This is Neha Lal versus Abhishek. Matrimonial तो क्या पूरे In fact, the law is evolving towards that area where mindless and endless litigation in matrimonial matters should be stopped.
Yes.
Like in some matters, the Supreme Court is interdicting High Courts, do not take up these matters, we are taking up. Some pan-India cases, some particular act or something. And this is high time, like all maintenance, one court, 125 DV, that is already there by direction by Supreme Court. Take up together and decide it. And this case, the offshoot, all these things, and no substantial question also, even whether the decree is satisfied or not, that is not also again an issue here. What I was to, I spent almost more than 1.5 hours. Yes. Say Memota the left. Like say Chaudhary Mr. Pujari Dev. That was only a suggestion Mr. Pujari to Mr. Pujari. Mr. Pujari will give it. I only suggested Mr. Pujari that instead of you giving, the petitioner should give. Let that go on record. Mr. Mohanty, mentioning something.
My lord, item 25. Wife has come. He wants
1,000 cash cost or what?
No, only two cases. That is DV case and this is against 125, your lordship. Husband has
So
come.
kindly tell the number again, 25.
25. Item
Achha.
25.
Oh.
ସେ ଚାହୁଁଛନ୍ତି ୱାନ୍ ଟାଇମ୍ ସେଟଲମେଣ୍ଟ ହେଇଯିବା ପାଇଁ ଏବଂ ଅଦର ସାଇଡ୍ ଆଡଭୋକେଟଙ୍କୁ ଆମେ ଜଣେଇଛୁ ମାଇ ଫ୍ରେଣ୍ଡ ଇଜ ଅଲସୋ ଇନ୍ ଦ ଭିସି
He is not coming to High Court. He is busy in Bhubaneswar.
My lord, I may be excused.
So they want reconciliation and mediation. So this is a welcome.
My brother has. Yes, lords. Yes, lords.
My concern is lordship's intervention.
Item 25 Lekantu, the matter is taken up on being mentioned by the Learned Counsel. Mr. Pujari, it was only a suggestion to you. I cannot say who will file. Still, I will suggest that let her file. But anyway, since you are the counsel, you can file. How can I insist that who will file? It was only a suggestion for you. That matter, since you are not there, I got hold of Mr. Lenka. That 44 cases, the last part is very important, is also interesting. The Supreme Court has imposed 10,000 cash cost on both the sides. 44 cases is against each other. The Supreme Court has granted 142, 141, that 142.
That's not like did not join issue on that point.
No,
It
no.
was better. And your lordship was better.
No, yes. What I would, Mr. Sushanta Das for the petitioner, Mr. Sanjeev Mohanty for the opposite party. Hybrid mode. It is submitted by the Learned Counsel for the opposite party, wife in the marriage, that the wife is present before this court and he has instructed. You are filing any kind of memo or anything, or simply I have observed?
Just now I can find memo.
No, why lordship will say that? Is your
My lord, I can fight.
okay. It's submitted by the learned counsel. But Mr. Das cannot sign the joint memo. What is it? And she has instructed the learned counsel to go for amicable settlement between the parties for resolution of the whatever dispute. That and the resolution would be acceptable to both the parties. The learned counsel, Mr. Das, appearing for the petitioner, being present in VC, submits that he also endorses the same said view that parties can go ahead to resolve the disputes amicably. Stop. The learned counsel for the opposite party files a memo, which is taken on record. The petition stands. You want referral to mediation or
mediation that would be
before the court annexed mediation? The matter is
High Court mediation.
Referred for mediation before the court annexed mediation center. Stop. The learned counsel for the parties shall appear before the coordinated mediation center. आज के तारीख आज 12 तारीख केबे गले हम आपण केबे डेट नहीं परिबे ते से आपण तम जणेबे आपण माने आगो सेटिके अधिका केस अछि त आपण डेट कियंतु आलो केबे आपण केबे जाई परिबे कोर्ट मेडिसिन सेंटर को सेटा Mr. Das, now they are saying that whenever you come to the mediation center, on which date you are coming to Cuttack, they want that date.
My lord, in the second week of March, if it is possible.
No, not for the parties. Only for any you or your associate will go to the mediation center and get the date. It may be March, second week of March. Sorry, next week.
First week of March.
No. As a lawyer, you only appear. The parties will not appear in first week of March. The lawyer will take a date from the coordinated mediation center. Then why so much of time?
Yes, then within next week.
So you suggest that date? Mr. Mahant is saying that.
My lord, 23rd, if it is possible.
I have nothing because it is your call. 23rd, the matter will be taken up before the mediation center for fixing a date of mediation.
Yes, lordship.
Please, sir. I requested to appear before the coordinated mediation center on 23rd February 2026. On the said date, a date for mediation shall be filed before the allotted mediator. The parties shall appear before the mediator as would be directed. The matter stands adjourned. 23rd February, March, April. The matter stands adjourned to
My lord, interim order may be extended.
Adjourned to be listed in the week commencing 20 April.
My lord, March because the maintenance amount has been stayed for that reason, your lord.
ଆପଣ ଇନଫ୍ୟାକ୍ଟ ଆପଣମାନେ ଆଗ କଥା ହେଇଥାନ୍ତେ ଝିଅ ସାଙ୍ଗରେ କଥା ହେଇଥାନ୍ତେ ସେ ପୁଅ ସାଙ୍ଗରେ କଥା ହେଇଥାନ୍ତେ ଆପଣମାନେ କରିକି ଭଲ ହେଇଥାନ୍ତେ ତାହେଲେ in the week commencing 30th March 2026 by the state date mediation report interim report shall be placed on record.
Lord, interim order may be extended.
Interim order as passed earlier shall continue till in the next date of hearing. ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି ଭଲରେ ସେଟଲ୍ କରିଦିଅନ୍ତୁ whatever possible. Yes.
Obliged, lordship.
Yes. Best. Memo, so Mahathir, give a memo.
My lord.
Yes, please. Next.
Item I. Please, my lord.
Yes.
The petitioner is a farmer, and from his
Assigned to your lordship.
Procurement and distribution PDS. Procurement more assignment.
no, sir, this is not procurement. Procurement of paddy, that irregularities is there, so that investigation is.
Sorry.
There is a corruptions in the Dhanamandis. So then
So
procurement, my lord, procurement.
procurement is not my jurisdiction, and if it is a PIL, still not my jurisdiction. Residuary matter, single bench, also not my jurisdiction. So Lenka has examined this earlier because three matters were listed. Your name, sir?
Somyaranjan Swami.
Mr. Somyaranjan Swami on behalf of SK Dalal for the petitioner. Mr. D.N. Lenka for the GA for the opposite party. The issue involved in the writ application is procurement of
Paddy.
paddy for the Bin Kharif season 25-26, not 24-25, 25-26.
No, 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 this is-
24-25 and also allegation of corruption.
24-25 with certain allegations of irregularity stuff. The subject matter is not within the determination of this court. The matter shall be the learned stop. The learned council has liberty to move the registry for listing of the matter before the assignment.
Item 9.
Yes.
My lord, in this case, my lord,
For the petitioner. Yes.
my lord, petitioner seeks to direction from this lord, from this honorable court, to
Yes.
stay the further proceeding of the DP execution case, my lord. While the,
Secure the decree, sir.
my lord,
For stay of execution, you have to secure the decree, not at the whims and fancies of the judgment debtor. If there is any provision, then please cite.
so my lord, one statutory appeal is filed before the Lord and District and Session Judge, along with an stay application, my lord. So continuous absence of the Lord and District Judge since first week of November, the petitioner is
Sir,
remedial.
absence, the case is assigned.
My lord,
If the any honorable judge is absent,
yes, sir.
the case is assigned to another bench. This is which district?
My lord, Bolangir, my lord.
Balangir, the district judge is there.
No, my lord, District Judge has not.
Who is the administrative judge of Balangir district? In High Court.
My lord,
So then how you are telling me this?
my lord,
How I will not know that nobody is there in charge of the district judge?
my lord, there is charge of
So-
District Judge, my lord, but the appeal is not hard and so it is admitted. LCR call for. Unfortunately, the scan copy of the LCR has come.
Sir, those are not grounds to interfere. We ensure not all this.
Yes, sir.
Wherever there is dearth of persons, so somebody is in charge and full-fledged charge. There is no limitation on the powers
my
to be
lord,
exercised.
the charge judges is not inclined to hear the matter.
You move, sir. You have to obtain an order that when he
Yes,
says that I am not inclined to take up
Your
the
direct. Your lordship may
I
direct.
am not direct. You have to move the court to pass that order. Then you challenge it. This disinclination of the part of the ADJ in charge
My lord.
cannot be inferred by a speech or my impression that he is a bad person. He doesn't.
No, my
It has to
lord.
be on record. So you have to show me on record that he is not inclined to take up the matter.
So, my lord, Lord and Lower Court in execution proceeding, I have taken several attempts, my lord. The matter is not taken up by the
Sir, he cannot.
charge judges, my lord.
So let us assume somebody becomes the district judge Balangir. Can he stay the execution without securing the decree?
So, my lord, there are many suppression of fact which is ought to be disclosed in view of section 26 of the Domestic
Sir,
Violence Act, my lord.
if you listen, it will not register. The question is, you have to answer is binary. Can the executing court stay the decree or the appellate court without securing the decree? That's the question to you.
Yes, my lord, on the ground of fraud, my lord, because
Show some case law on that.
My
Without
lord,
securing.
mandatory provision of the DB Act, my lord, section
Sir, you are not
26.
listening, sir.
My lord, on
Sir, you are not listening. We are going to speech. It is a deliberation. Cite a case law where the court, without securing the decree, can stay it.
so I want the final hearing of the appeal, your lords.
You should want that. But the court wants that the decree has to be secured. You want a final hearing of the appeal.
So, my lord, I am remedialist because the
My lord, my stay application is still unheard, my lord.
Sir, your decree, you are a judgment debtor. Sir, you are a judgment debtor. You are not securing it. You do not want to pay the person, the decree holder. That's a different thing. But you do not want to secure it. Who is asking you to pay it? Who has asked you? Yes?
My lord.
Who has asked you to pay the money?
My lord, Lord JMFC.
So you are, no, after that, has the appellate court asked you to deposit the money? To pay it. You have to secure the decree. You can't secure it in any manner. Have you read the case law on this? In DV Act 125 CRPC, what is happening? In absence of the district judge, you cannot become the district judge to stay the execution, stay the decree. What is the provision regarding execution of decree? Appeal. In appeal, what is the condition to be imposed?
My lord, the decree has been passed on serious suppression of facts.
Very good point, sir. It's a decree. Is there any provision in CPC then when serious suppression is alleged, the decree automatically gets stayed?
Section 47 of CPC.
Can we read 47? That if the appeal is filed, the decree gets stayed? Yes, read 47.
So, my lord, this is
the common laws are not prepared.
My executing court decree, but when the fraud
when you challenge a decree, what is the conditions? Section 47, yes. What is the provision? They see that if there is a serious allegation of fraud, then the decree gets stayed. Half-baked, sir, never works. Half-baked stories, and especially in law, is very difficult to sustain. Executive court cannot, or the appellate court cannot go into the possibility of success in an appeal. Please appreciate. You want to secure the decree or not? That's the question put to you. Let us not spend time.
No, my lord, I am not.
You will not secure the decree, then it is dismissed.
So, no, my lord, I am wants to secure the decree. I am a judicial. My lord, I am the judicial officer, my lord. I wants the conciliation, my lord. So, since my lord,
sir, you want to secure the decree, secure it by affidavit. I will state.
Yes, your lordship.
What is the amount due?
My lord, the order. Since 2023, my lord, under Annexure 1.
So, what is the date of the?
My lord, 15/9/25, my lord.
7/7/23.
7/7.
So total due amount is?
My lord, monthly maintenance, my lord, 15,000.
Oh.
Total.
Kete hela? 3,60,000 plus another 6 months. 4,50,000 deposit करंतु से पाइबे ना से fraud interest होता है अपन पाइबे फिर. When you will deposit?
Your lordship.
Sir, it's a serious. You are a judicial officer.
My lord.
And still you are sitting over a decree. Under what authority?
So, my lord, several attempts.
My lord, several attempts.
My lord,
under what authority? Sir, under what authority you are sitting over a decree, which is binding on me?
So, my lord, why
you are not securing the decree?
So, I fairly submit if your lord, I want to secure the decree, my lord.
Sir, why are you not securing since 23, 25? Is the court unfair to you? Or you will say everything because you are a judicial officer? Become Supreme Court?
No, my lord. No.
Then under what authority you are saying this?
I want a permanent settlement, your lordship. That's why the process.
Sir, say something on law. I can record and reject it. Already it is recorded. In case a permanent settlement is sought for by the petitioner, then the decree is stayed.
No, my lord.
So then please don't make
your lordship.
Please submit something which makes sense in law. You must understand where you are in a court of law. Law is not here to at your choice or to please you. At your own sweet will, you will comply, or if you are supposed to pay, you will not pay because you are a judicial officer, because your serious fraud is committed. You deposit the amount. Don't give the money. By which date you will deposit 4,50,000? Which date? File memo just now. Passed over.
My lord, lords.
I cannot pay. I don't have that much of money. Or you cannot pay.
No, your lordship.
You filed a memo that you want to secure the decree.
Yes, your lordship.
File it. Kagas do. Next matter call karo.
Item 10.
Passed over. By which date you will file, so that I will issue notice. केबे देबे मते कुहतु आग पर चले के 50,000 कोठी देबे केबे देबे?
My lord, just within 5 minutes I am
अच्छा इंस्ट्रक्शन लागो.
Yes, of course.
So दुखरे जिसडा तो नाही इसे हबनी केस.
No, my lord.
We will have a reading question, instruction question. Yes, item 10. Yes, Mr. Patra.
Petitioner filed this contempt application for the arrear salary as per the judgment of the Hon'Ble Court dated 21/11/2017, and that was also challenged by the state government in Apex Court, which was dismissed on 16/4/2024. After that, they have calculated my salary on
Page 32.
page 32, Lord. See, they have calculated my salary on 13th March 2025, but till yet they have not paid it. So, my only prayer is for the release this arrear salary.
That part I have to take instruction whether it's.
Sorry, वाला तो comply है वाला.
He says that.
I'll lend the पैसा.
पैसा पे.
तो order है क्या कौन होगा? Court order, Supreme Court order, government order.
March reach.
ठीक है जी.
13/3/2025.
तापर कौन है ला?
आज तो रिलीज करना चाहिए.
You must address the court that after passing of the order by the government to pay you the money, then what has happened?
They have not paid it. Only they have calculated this amount only. They have got.
Who is your drawing and disbursing authority?
My lord.
District Education.
District Education Officer Balas.
Kindly look at page mark 9 ना कौन? Page 32 ए देखो तो ताको तो copy भी दिया है.
Yes.
तापर कौन है ला?
Only this is the calculation they have made it, and they have supplied me.
Sir, सेटा 5 थोड़ा पहले.
Salary, they have not released the financial benefit to me till yet.
Any idea what has happened after that? You have to say that I do not have any idea. What is this answer? You will say one thing 5, 6 times.
They are saying that we will pay it when the director will again say to finance clearance, then only we will pay it. This much only they are saying.
So have you stated that in the petition? What you just now said in court, have you stated that in petition? You have approached such and such authority?
Yes, I have made only after I have made it several times.
You obtain instruction?
Yes. But in the memo, next page, your lordship will find the account section of this office for information. They are instructed to prepare the bill immediately for compliance of the order of the honorable office. That part I have to take issue.
So, sir, and the problem is Mr. Patra should have asked this question to his client. Before what happened after, because the order is there.
Yes. I take instruction whether if the amount has not been paid and why that happens.
And G it is your duty as a lawyer that you bring that on record. So that instruction, that was the purpose. जे आपण क्यों हैरान करछन यदि को गवर्नमेंट ऑर्डर हैला ताल पैसा कहीं देबेनी
DO is
yes. And also it is a legal due.
Yes.
Legally you are entitled to court order. But आपण से जगह रे आपण किछ कहू ना.
Not only this 1%, all those 13%, except this Dikshit, all 13% have not get their arrear salary from 2023 till 2024.
The petitioner alleges non-compliance of the order passed by the coordinate bench. Dated
7/21 21/11/2017.
21/11/2017 passed in WPC number 15209 of 2013. Stop. The said order was challenged before the Honorable Apex Court by the opposite party state in SLP into bracket C.
Sixteen for 24.
SLP
page 29.
Page 29.
SLP C to lekha hai.
তলে রয়েছে SLP
SLP C number
7198.
7198
SLP to bracket C number 30079 of 2019 and SLP C number 7198-7205 2019.
ଆଉ ଗୋଟେ ଉପରେ ଅଛି 7197 ଟପ୍
ସେଇଟା যেটা আমি
সেটা তো আপনার ইয়েটা লিভ প্রফিল
Yes.
সেটা SLP C নুহ
yes.
ହେଲା by the order dated 16/4/2024 the Honorable Supreme Court has dismissed the SLP
dismissed para 3.
Para 3 of the operative post, para 3 of the order passed by the Honorable Supreme Court is reproduced herein. Para page 30 ରେ ଅଛି. ହେଲା? It is submitted that after dismissal of the SLP, the District Education Officer Balasore has issued office order dated 13/3/2025. Fixing the pay of the petitioner herein. ଅନାଦି ଚରଣ ପାଣିଗ୍ରାହୀ ତାଙ୍କ ନାଁ କଣ ପିଟିସନର ନାଁ କଣ fixing the pay of the petitioner with effect from 01.12.2003 along with subsequent increments. After the order has been passed, after this, the order dated 13/3/2025 has been passed, the petitioner is not aware of the further developments. The alleged additional government advocate seeks adjournment to obtain instruction regarding the release of the money after the order dated 13/3/2025. List. How much time, Mr. Lenka?
No, on 2 weeks.
List in the week commencing 30 2/3/2026. Yes. List for orders orders as yes.
In this case, my lord, filed a some stay because my lord, the maintenance.
Mr. Bishop Prakash Nara for the petitioner, Mr. Suraj Mahanti for the opposite party.
The lordship kindly see the order dated 20/2/24. The rate for the issuance of the limitation 50,000 to deposit.
Yes.
Thereafter, my lord, next order, my lord, 21/24.
That what is that?
For issuance of notice for
There was a delay and this honorable court has directed to deposit 50,000 rupees.
na eta heichi
FD ରହିବ ହେଲା fixed deposit ହେଲାନି
No, I have deposited before this honorable court by demand draft. If your lordship kindly have a glance to the order dated 21/3/24.
Yes,
I have deposited.
yes.
My lord, if your lordship will kindly have a glance to the order dated 13/11/2020.
Yes.
Yes.
The validity of that demand draft was lost. And this honorable court has directed to return back that DD and pay that amount to the, my lord, the wife opposite party in the learned court below.
Yes.
I have returned back and paid that.
So that is reflected in order dated 10/1.
That 13/11/24.
13/11.
ଜାନୁଆରୀ ପହଞ୍ଚିଗଲୁ ଆପଣ ବହୁତ ପଛୁଆ ଅଛନ୍ତି ଜାନୁଆରୀ 25 ରେ ଆମେ ପହଞ୍ଚିଗଲୁ ଆପଣ କଣ 24 କୁ ପଳଉଛନ୍ତି ଫେର
ନାଇଁ ନାଇଁ ଏଇଠାରେ ସେ କଲେ ସେଇ ଯୋଉ 50,000 ଟଙ୍କା ଡିପୋଜିଟ କଲେ ଯୋଉ ସେଟା ୱାରେଣ୍ଟଟା ଷ୍ଟେ ହବ
ଆଜ୍ଞା
ଅର୍ଡର ପାସ୍ କରିଦେଲେ ଏତେ
ସେ ସରିଲାଣି ପରେ ସେଇଟା ଅର୍ଡର ପଳେଇଲା
ହଁ
ସେଇ ସ୍ପିଡ୍ ହେଇଯାଉଛି ନା କଣ
ନାଇଁ ନାଇଁ
ତାପରେ କଣ ତାପରେ ସେ କହୁଛନ୍ତି 50,000 ଟଙ୍କା ଦେଲୁ ବୋଲି କହିଲେ
ହଁ ସେଇ 50,000 ତାପରେ ସେଇଥିରେ ଅର୍ଡରଟା କନଭର୍ଟ କରିଦେଲେ ସେ 50,000 ଦେଲେ
ମତେ ବୁଝୁଛନ୍ତି କାଇଁ ଅର୍ଡରଟା ଆପଣ ମାନେ ବୁଝିବେ ନା ସେ ତାପରେ ହେଲା କଣ ମୁଁ ପଚାରୁଥାନ୍ତି
ସେ ବର୍ତ୍ତମାନ କୌଣସି ମେଣ୍ଟେନାନ୍ସ ଆମାଉଣ୍ଟ ଏପଟ ସୁଦ୍ଧା କିଛି ଦେଉନାହାନ୍ତି
କାଇଁ ଦଉନାହାନ୍ତି
କିଛି ଗୋଟେ
ଆପଣ ବି
5 ବର୍ଷ ମାନେ
ଆପଣଙ୍କର ଯୋଉ ସେ
ପଡିଲାଣି
ହଜବେଣ୍ଡ ମାନେ ସେଟା ହବ ସେ ହଉଛନ୍ତି ସୁପ୍ରିମ କୋର୍ଟ ସେ ଯାହା ଚାହିଁବେ ସେ ହବ
ତାଙ୍କର ଟ୍ୟୁଟୋରିଆଲ ଇନଷ୍ଟିଚ୍ୟୁଟ ବି ସେ ଚଲେଇଛନ୍ତି
କିଛି ନାହିଁ ସେଟା there was no evidence at all.
ତାହେଲେ କାହିଁ କେସ୍ କାହିଁ କରୁଛନ୍ତି ସାର୍ why you are clogging up the I mean the doors of the court I mean you are adding to the backlog you are non-compliant.
No, my lord, I have complied.
So you pay what is the total amount due now?
Now my lord more than 2 lakhs above I think
He is in
ଆପଣ 1.5 ଲକ୍ଷ ଟଙ୍କା ଦେବେ ନା ନାଇଁ କେସ୍ ଡିସମିସ୍ ହବ
a drastic condition. He is getting only 5,000 to 6,000.
sir he may not get anything but for that court has to go by the law or by personally ବୁଲିକି ପଚାରିବେ କାହାର କଣ ଅସୁବିଧା ଅଛି
No, my lord.
ଆପଣ ଯଦି ଚ୍ୟାଲେଞ୍ଜ କରିବାକୁ ଚାହୁଁଛନ୍ତି ଆପଣ ଯେଠି 50,000 ଟଙ୍କା ତ ଡିପୋଜିଟ୍ ଯୋଉ କରିଥିଲେ
My lord.
ଆପଣ ଏଠି 1.5 ଲକ୍ଷ ଟଙ୍କା ଡିପୋଜିଟ୍ କରନ୍ତୁ
So it is very difficult for him to
sir I cannot do sir I cannot I have no capacity to substitute law by own money and you may pay him if you are concerned and say these things in a legal forum what is the consequence can I direct that so it is so difficult for him he cannot deposit so the law goes to
No, my lord. On a presumption, the learned trial court, my lord, the judge.
sir you are arguing on merits I am not listening on merits your lauded friend has now come 4,50,000 area
फिफ्थ क्लास पढ़ुची पुआटा किछि नाही तब यार भाईटा एई केस तक से सुसाइड कर मरि गला रिसेंटली
सेटा छाडନ୍ତୁ सेटा आपण गोटे सुनो तो everywhere the lawyer is present you file another case in tort you will argue remoteness of damages
very pathetic condition
ଆପଣ ପଇସା ଦେବେ ନା ନାଇଁ କେସ୍ ଡିସମିସ୍ ହବ ଅର୍ଥାৎ ଦିଅନ୍ତୁ କୋଉ ଦିନ ଦେବେ affidavit ଫାଇଲ କରନ୍ତୁ ଆପଣ ସିନିୟର 메ମୋ ଫାଇଲ କରୁଛନ୍ତି ଦେବେ 4,50,000 ଆପଣ 2 ଲକ୍ଷ ଟଙ୍କା ଡିପୋଜିଟ୍ କରନ୍ତୁ ଭାଇ
50,000 ଟଙ୍କା କୁହନ୍ତୁ
ନା 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 ମୁଁ ପର୍ସନାଲ ପଇସା
ତାର କ୍ୟାନ୍ସର ପେସେଣ୍ଟ ସେ ଘରେ ଅଛି
ସାର୍ କୌଣସି ସାର୍ ଆପଣ କେସ୍ ଲ ଆଣିବେ ନହେଲେ ସିପିସି ଦେଖେଇବେ କି ଫ୍ୟାମିଲି କୋର୍ଟ ଆକ୍ଟ ଦେଖେଇବେ ଭଉଣୀଙ୍କର କ୍ୟାନ୍ସର ହେଇଥିବ ଘରେ ରହିଲେ ଆପଣ ଲିଗାଲି ନୂଆ ସଲ୍ୟୁସନ କରନ୍ତୁ ଡୋଣ୍ଟ ଗो ଏଭରିଥିଙ୍ଗ ଆଙ୍କର ସମସ୍ତଙ୍କର ବହୁତ କିଛି ଦୁଃଖ ଅଛି
I have to pay because I have to pay, my lord.
ଆପଣ ତ ଶୁଣିବେନି ଏଇଟା କଣ ଡିବେଟିଂ କମ୍ପିଟିସନ କି ହ୍ୱାଟ ୟୁ ଆର୍ ଆର୍ଗୁଇଂ ଆପଣ ଆର୍ଗୁମେଣ୍ଟ କଣ କରୁଛନ୍ତି ଆପଣ ଗୋଟେ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ଏ ଡିକ୍ରି which is we are a judgment better ଆପଣଙ୍କ ଭଉଣୀଙ୍କର କ୍ୟାନ୍ସର ହେଇଛି ସେ ରହୁଛନ୍ତି ସେ କଥାରେ କଣ କରିହବ ସେଥିରେ ଯୋଉ ଆପଣଙ୍କର ସିପିସି ରେ କଣ ଅଛି ବା ଫ୍ୟାମିଲି କୋର୍ଟ ଆକ୍ଟ ରେ କଣ ଅଛି ବା ଲେଟ୍ ଅସ୍ ସେ 2% ମୋର କଣ ପାୱାର ଅଛି what power I have why does the sympathy comes as far as the law is concerned
No, there is no.
so ଆପଣ sufficient time ପାଇଲେନି ଆପଣ କେବେଠୁ ଆପଣ ଦଉନାହାନ୍ତି
22 ମୁଁ ଡିପୋଜିଟ୍ କରିଥିଲି 24 ରେ ଡିପୋଜିଟ୍ ହେଇଛି
the problem sir Mr. Dhara you have to rise above this you have to tell the truth to your client that this is a decree you paid have you read the decisions on this have you read that Rajneesh versus Neha that for this kind of this the wives are running around courts they never come to court actually or notice being issued ତ ଆପଣ ଯଦି ଦେବେ ଦିଅନ୍ତୁ ନହେଲେ ଆପଣ ଇଏ କରେ
Thrice I have taken a notice against her. She did
ଆପଣ
not.
ଟାଇମ୍ସ ଦେଲେ କି 30 ଟାଇମ୍ସ ଦେଲେ ସେଟା ଯଦି ଲିଗାଲି ସଷ୍ଟେନେବଲ ସେଇଟା କୁହନ୍ତୁ ଯେହେତୁ ମୁଁ ଥ୍ରାଇସ୍ ନୋଟିସ୍ ନେଲି
ଭୁଲ ଆଡ୍ରେସ ଦେଇଛି
Whatever address given in the.
ସେଟା ଆଜ୍ଞା you are just joining the ଆପଣ you are absolved from the liability because you have taken thrice notice.
No, my lord.
So then I have to can you accept that contention? So why you are wasting
My
time?
lord, I have taken a willful desertion and my lord, the.
Sir, on merits, she will pay you back the money if she is not entitled.
He never.
Sir, ଆପଣ suit file କରିବେ ଏଇଟା କଣ what I am doing here ମାନେ listening to speeches or what?
Your lordship.
So you make a submission confined to the within the four confines of law.
Your lordship will keep it to on some another day so that I will take a instruction.
You need not take any. I am not here to request you to comply with the court's decree.
No, my lord, I am.
So you request. I am not supposed to do that. That's illegal order. Why should I request you? ଆପଣଙ୍କ ଆଇଏଟା କେତେ?
ଆଇଏଟା ହେଲା my lord, that is
IR of
67/22. Very well. ଆପଣ ଯଦି ଟଙ୍କା ଦେଇଥାନ୍ତେ ତାହେଲେ ଏସବୁ କଥା କହିବାକୁ ପଡିନଥାନ୍ତା। ଆପଣ ଆଇର କପିଟା ନେଇ କଣ ଡିଫେନ୍ସ
On a subject of payment of 50,000.
ଶୁଣିବେ ନା ଶୁଣିବନି?
Yes.
କଣ ଆଇରେ ଆପଣ ଡିଫେନ୍ସ କଣ କୁହନ୍ତୁ ବର୍ତ୍ତମାନ ମୁଁ ଲେଖିବି।
No, my lord, on a direction of this honorable court, I have deposited 50,000 rupees. On depositing, this honorable court has directed
the other amount to be paid. Yes.
Well,
while directing you to pay 50,000, the court has exempted you from paying other amount. Warrant. Nothing.
Only
you are not arguing.
My lord, I will pay. Your lordship will grant some time.
Sir, enough time has been granted, sir.
If your lordship will keep.
Sir, I cannot extend the time by granting
next week so that I can arrange and pay. My lord.
Sir, you pay or you do not pay. That is your choice.
No,
it is not my job to request you.
No, your lordship will. I am, my lord, praying that your lordship keep it to.
Sir, your prayer will be noted and rejected. No difficulty. Who is not quoting your prayer? I try to record everything.
Keep it to next week so that
but you have to file that memo that you are doing it.
Well, the current dues.
You see, the entire area you have to clear up. You are enjoying something since 2022. After filing the petition, you have become the Supreme Court for the last 4 years. So you continue to become the Supreme Court.
My lord, I will keep it to next week. I am praying that your lordship will keep that.
Sir, either you pay or don't go on repeating a statement as if I do not understand.
I will.
Lordship keep it to next week. You have said 5 times. It doesn't become into square so that it will be going to the next week. ଆପଣ ପଇସା ଦେବେ ନା ଦେବେନି?
ଦେବି।
ହଁ ଦେଇ ଦିଅନ୍ତୁ। ମେମୋ ଦିଅନ୍ତୁ। ମେମୋ ଲେଖିକି ଦିଅନ୍ତୁ କେବେ ଦେବେ?
I will take instruction.
ତାହେଲେ ସେଟା କୁହନ୍ତୁନି। Sir, you are at the mercy of your client. Court is not at that mercy. It is your choice.
I will.
If the lawyer is at the mercy of the client, it is his or her choice.
That is why I have.
Sir, don't quote sorry figure for your client and compel the court to pass illegal orders. This has become really, no semblance of. IA 67 of 2026. You take your seat and take some time to dictate the order. The petitioner husband is before this court, challenging the judgment dated 12/4/2022, passed by the learned judge, Family Court Puri. आइए संगरे मिसेक लिखिबे अपील का। By the said judgment, the petition filed by the wife and the minor child, then aged about 2 years, seeking monthly maintenance under section 125 of CRPC, into bracket, since repealed and substituted with parametric provisions contained in Bharatiya Nagarika Suraksha Samhita, was allowed. However, instead of granting a maintenance of 15,000 as paid for, rupees 3,000 was directed to be paid for execution file करछन्ति. Why have not filed execution?
Execution has been filed.
So that order I am vacating. कौन लिखिले? 15,000 as paid for, rupees 3,000 per month was directed to be paid towards the wife and rupees 2,000 per month to the minor child from the date of application. That is 16/9/2017. The judgment of the learned judge family court was challenged by filing the present revision application. By order dated 22/2024, when the matter was listed for the first time, the entire amount of money remaining unpaid, though due since 2017, the coordinate bench directed for deposit of rupees 50,000 in the registry as a precondition for issuance of notice. By 13/11/2024, another coordinate bench allowed the petitioner to take back the demand draft, which had by then was outdated, and 50,000 was directed to be paid to the opposite party. And stop.
High Court
Order dated by the state order dated 13/11/24. The execution proceeding filed by the opposite party for the amount of maintenance, which is about 3 lakhs by then.
ସାରଙ୍କର ମୋବାଇଲ ମିଳିଲାନି ନା କଣ?
7 ବର୍ଷ
ମନ ଦୁଃଖ ସାରଙ୍କ। ହଁ ଦେଖିବେ ଏଟା ଗୋଟେ ମାସିକା କଣ ଦେଖିବେ ଯେବେ ଆପଣ ଡେଟ୍ କରିବେ ଆଉ ସବୁଡା ଗୋଟେ।
This is gross misuse of process of money.
ହଁ ଠିକ ଅଛି, ଥ୍ୟାଙ୍କ ୟୁ।
ଖାଲି ବାକି ରହିଲା କୋଉଦିନ ଆପଣ ଯିବେ, ଆପଣ ସାଙ୍ଗରେ ଜଜ୍ ବି ଯିବେ, ତାଙ୍କ ଘରେ ଯାଇ ଛିଡା ହେବେ, ତାଙ୍କ ଦୁଆରେ ଛିଡା ହେବେ। ଚୌରାଶୀ ମାସ ହେଲେ କଣ ଲେଖିଲେ? Was interfered with by directing stay of NBW and DW passed by the executing court video order dated 13/9/2024. In the IA, it is stated and submitted that apart from paying that amount of rupees 50,000, nothing has been paid. As the petition was heard on merits, the learned counsel for the petitioner candidly states that the petitioner has not paid any other amount. It is further submitted by the learned counsel for the petitioner that petitioner has very good reasons for not to pay the amount and remain in default of the direction for payment of maintenance. From 16/9/2017 till 16/9/2024, for the 84 months, the amount due comes to 84 into 5,000 equal to 4,20,000. Apparently, the petitioner has taken advantage of pendency of the RPFM before this court. Business versus Neha. Purata lecture. Has been held at paragraphs. Has been held by the apex court at paragraph dash the court of attack. Being asked whether the petitioner is ready and willing, what steps has been taken for the petitioner to secure the amount that is under challenge before payment of which is under challenge before this court. The learned counsel for the petitioner also concedes that the said amount has not been secured. Apart from complying with the direction to payment of rupees 50,000, accordingly, the order dated 13/11/2024 is modified. The learned executing courts shall proceed with the execution. Copy of this order shall be communicated to the learned executing court by the registry. Yes, now Mr. Dhawan, now you have an opportunity. This order will be conditional. How much you will pay, by what time? Or execution will proceed.
My lord, my predicament is unless and until I will take instruction.
The learned counsel for the petitioner commits that he has the predicament of not receiving instructions from the petitioner, who is enjoying the stay order granted by this court, which is contrary to the law laid down by the apex court in Rajneesh versus Neha. The learned counsel is also asked whether to stall the further proceeding in the execution, the petitioner will deposit any amount even after stop. Even after 4 years of filing of the application, more than 3 years of filing the application, it is stated by the petitioner, learned counsel, that he has no instruction. Yes, you proceed in the execution.
If your lordship will allow some time to me, then I can assess your lordship.
I am no one, sir. You are so big person.
No, my lord, I have tried.
Sir, you are capable enough to survive the execution for 4 years. You can survive. I have no difficulty.
I have tried.
Sir, I will not be party to your illegal activity. Don't expect the court to be party to the illegal activity of obtaining stay order.
That is for some time, my lord.
Yes. The learned counsel for the petitioner takes the plea that the petitioner should be given enough time to comply the decree. In considered opinion of this court, after the petition was filed on 22/8/2022 before this court, 3 years, 6 months have passed, which in any view of the matter is sufficient time. And this court cannot exercise jurisdiction to extend any time in any manner whatsoever. You must understand, sir, what order I will be passing. ଆପଣ କହିବେ sufficient time ଦିଅନ୍ତୁ। 2017 ମସିହାରେ ଡ୍ୟୁ ହେଲାଣି। ଆପଣ 2000
praying only
sir, don't pray, sir. Don't prayers are made when making illegal prayers, not before the courts.
So
you must understand, sir. ଆପଣ 9 ବର୍ଷରେ decree satisfy ହେଇପାରୁନି because of our interference. We must look at ourselves. Why they are not appearing? 17 ରୁ 26 ହେଇଗଲା, still the matter is pending. Anyway, yes, ठीक ଅଛି. Yes, passover matter.
Your lordship will keeping it to final hearing.
No final hearing. ଆପଣ କେବେ ଚାହୁଁଛନ୍ତି ଡେଟ୍? Final hearing for non-compliance.
No, my lord.
I'll record and reject the prayer.
No, the merit of the case.
The merit of the case because you are not compliant, dismissed. Today I'll dismiss it, no difficulty. No merit.
My lord, otherwise he is...
Sir, I have already passed judgments, detailed judgments dealing with all the points.
No, my lord, I have...
Have you read which is the decision on revision?
I have not gone through because
It is listed. After accepting the brief in 2022, you should have started reading.
No, my lord, it is listed for limitation on the question of limitation. My lord. The delay has not been...
Correct. There is no merit.
Lord,
because if you read the revision scope of revision of Supreme Court, and that is by a famous judge from our state only, you will understand that there is no case. You have not made out any case.
my lord,
It is much easier for me to dispose of your case than passing these long orders. You read your petition, there is nothing.
my lord, there is a willful desertion.
Correct, sir.
My lord.
For willful desertion cannot be determined in a 125 CRPC.
In a 125 petition, she should have, my lord, proved what is my income.
Correct.
My lord, I have given evidence that I am earning 6,000 to 7,000.
Yes.
Well, that has been affirmed by the statement of the father-in-law.
Correct.
The father of the wife. Well, still then the...
Have you read any decision on this or making a speech?
No, my lord, I am...
Sorry, we are not listening to you. Because you are, as if you are taking a lecture on revision. I am asking you repeatedly, have you read it when you accepted the brief in 2022?
My lord, I have gone through that. My lord, fact, I have gone through that.
Not fact, the law on the revision of a order in 125 CRPC. There is direct decision on these points.
That is why I am praying, my lord, if your lord will kind enough to
but there is a time
to give him a chance, my lord.
Sufficient chance has been given. I have recorded, sir. I have recorded that granted, but I have recorded 4 years is enough time.
Next week, if your lordship will, I have
no next week. No next week, sir. It is not installments. I am wasting time, sir. You see, Mark, sir, I have given you for a this order leads to nowhere, but still I have taken half an hour. For what? Because you have, Let us not make this process of judicial process should not be made I mean, this has become farcical.
I will be prejudiced, my lord, otherwise, my lord.
Yes, yes,
misunderstood, my lord.
So you have prejudiced yourself what you will do. If you chop off the branch where you are sitting, you should have availed that opportunity. You should have deposited the money here and got that reprieve from the court. If you had when he did not comply and did not deposit, you advised him.
Your lordship may direct for depositing of some amount so that
Sir, I am telling you,
chance to.
I have, sir, still have given you the opportunity. If you deposit, you mention liberty to mention. After you make the deposit, you proceed with execution. It will be communicated to the executing court.
That is, my lord, executing court will, my lord, proceed with the matter. My lord, regarding
Sir,
this matter, my lord.
Sir, we are taking up a matter of revision RPFM as far as the procedure established by law. Nothing beyond that. It is not a common room talk between you and me.
No.
So please leave it there. If you have anything on merits, then you please say.
Your lordship may direct for
Already directed.
some amount so
Yes,
that
amount has been directed, sir. Amount has been directed, calculated also.
that much amount at a same one time, my lord, he is unable.
It's not one time, 4 years, 7 years. 84, I have given the details also. 84.
Your lordship will, and that is true, my lord. But your lordship direct for some amount he could.
Sir, I am not there. Sir, it is not my money. It is your money. I am not receiving the money. He is receiving.
She will.
So I will not interfere there.
Well,
it is your choice. Taking chance with courts of law has its own limitation.
So that I would get a chance to, my lord, argue on the merit of the case, my lord.
No. The case has no merit. I will dismiss it. No difficulty. Yes, next.
I come to a. My lord, much obliged, my lord. So I obtained the instruction and showing the predicament. So my lord, 1 lakh will be given. With
No.
I have filing.
You say the amount. What is total due amount? What is total due?
My lord, 25 November रे order हला.
केबेठु हला total due केते हला आपन sir, you are wasting time. Same order as in Mr. Dhola's matter. You are taking chance and making
I am filing the memo.
Sir, this is not a joke we are having, sir. This is not a joke.
So, my lord, I want.
Sir, what is the amount due? You have to tell me. How much you have to default?
4 lakhs.
50,000.
4 lakhs around.
4,50,000. You have not calculated. Deposit the entire amount here. This is not my money or your money. Don't do disservice to your law by being a judicial officer. If you have not paid, it is your responsibility to pay.
Part payment may be directed, your lordship, 1 lakh maybe within 4 weeks. Man.
Sir, it is not, sir, I don't have the option to give you 1 lakh. 3 lakhs who will pay? I will pay. 3,50,000 who will deposit?
So, my lord, I will make the payment. I want to secure as advised.
Sir, because you have not paid, you have remained in default. I cannot take a different view from what Mr. Dhola's matter and Mr. Mahathir's matter.
My lord, I am permitted to withdraw my.
No. No withdrawal. Dismissal. No withdrawal. This is which matter? You are Mr. Swain.
Yes.
Yes, you take your seat. I have to dictate the order. That's your judgment. The writ application has been filed challenging the attachment and execution proceeding arising out of the order dated 15/9/2025 passed in CMC number 122 of 2023 pending before the Court of Learned JMFC Roman 3 Bolangir till disposal of the petitioner's stay application in CRLA number 10 of 2025. Have you annexed the order 15925 directing payment?
My lord, under annexure 1 is.
Yes. Yes, kindly take your seat. Sit at the level. The order dated 59/2025 was passed by the learned judge by the additional civil judge from JMFC, Balangir, in CMC case number 122 of 2023. Under section 23 of the Protection of Women from Domestic Violence Act, 2005, into bracket in short PWDV Act. What is his designation? Judicial officer?
My lord, Kyunjor, my lord, serving as a judicial officer.
What is his designation? ADJ, DJ, CJM?
My lord, JMFC. My lord.
The opposite party is a judicial magistrate first class. Salary देखले कितने? The opposite party is a judicial magistrate first class, opposite party husband. In the CMC case. This exact amount of buji pakade. Who is working now as a who now works, who as stated by the learned counsel for the petitioner, earns about rupees 1,50,000. Exact amount लिखियो underline करता है as salary. The direction was for payment of rupees 50,000 as interim monthly maintenance for survival of agreed party along with her minor child. From the date from 7/7/2023, that is date of application. In view of the judgment of the Honorable Apex Court in Rajneesh versus Neha, INSC re achi an exact paragraph in Rajneesh versus Neha, INSC जोड़ा citation टा दे देवे 2020 INSC into bracket 63 colon spelling mistake INSC 631 भूलभाल type होची colon 20 into bracket 2021 bracket close to SCC 324. That is guidelines, directions on maintenance. Referring to Article 15 into bracket 3 of the Constitution of India. The allotted counsel for the petitioner was asked whether he will secure the amount that remains unpaid since 7/7/2023. That is for 30 months. The amount comes to 15,000 गुणन 30, 4,50,000. The allotted counsel for the petitioner submitted that he wants to seek instruction. The matter was passed over. After about half an hour, the matter is called again. The allotted counsel for the petitioner submits that he has received instructions that the petitioner will not secure the decree, secure the defaulted amount of rupees 4,50,000. However, you are saying he may or he shall 1 lakh. The 1 lakh kebe debe kon debe koile? He can deposit up to 1 lakh for securing the decree. This has led to a situation before a High Court where a judicial magistrate being defaulter in a decree granted by a court of proper jurisdiction, which is in the nature of a money decree in view of Rajneesh versus Neha. The amount of 15,000 per month being the wife in the marriage and the minor child does not want to secure the decree to challenge the order on merits. Para. When this court expressed its view that the petitioner cannot bargain to suggest an amount of 1 lakh to secure the decree, the allotted counsel for the petitioner submits that is your choice or his choice to withdraw the petition.
So I being the conducting counsel, so
submits that though he doesn't have instruction, he being the conducting counsel wants to withdraw the petition. Para. In paragraph 20 of the decision rendered by the Honorable Apex Court in Samima Faruqi, the following has been laid down regarding scope of interference in a revision application. Coincidentally, Samima Faruqi dealt with a direction, dealt with scope of revision of an order directing payment of maintenance. Paragraphs 19 and 20 of Samima Faruqi is reproduced herein. Though the case is listed for admission, the prima facie reading of the order dated 15/9/2025 indicates that. So you test to likhi debe. You read Samima Faruqi, then you will understand. Accordingly, further the petitioner is not inclined to secure the decree during pendency of the petition. Secure the amount, decree no, secure the amount directed to be paid. Accordingly, in view of the discussions above, the petition is dismissed. copy of this order shall be forwarded to the lauded court. Under JMFC Balangi, before whom the execution case is pending. Yes.
Item 12.
We have filed a IA for avail the amnesty scheme, Lordship. That was floated by the
Amnesty scheme has been annexed.
My lord.
Mr. Somnath Mishra along with Mr. So disposed of Mr.
Yes, my lord. Well, the similar matter, Lordship.
On 27th of January.
Other matter also, your lordship disposed of the writ petition.
Correct. No, in fact, one matter, Mr. Mishra did not want for disposal.
What I beg to claim, Lord, in this case, that it
No,
will
my lord, so in 7 cases, on that day, on 27th of January, my lords, your lordship passed 5 orders and another matter was taken up after lunch on my request, my lords. And in all those cases, your lordship said that pending disposal of the writ application.
No, actually, Mr. Mishra, Mr. Mahapatra appeared in other matters. All those matters have been disposed of.
Yes, that's what he told me. But
So
only
so you are due to have disposal.
No, sir, disposal kartale kon again they will approach your lordship because they are.
The problem is because
your lordship may dispose of, no problem. No problem.
It is for the benefit of my senior.
No, not only that. Suppose now you reject the amnesty scheme.
Yes.
Then the said writ petition will not solve the purpose. So that is what I wanted to test.
Yes, Lord.
If at all the amnesty scheme is to be considered, it is a fresh cause of action, it has to be challenged.
Yes, Lord.
Your lordship may dispose of both the merits item.
Mr. Mahanti, can you see? Sir, देखो आपण देखो अरे मुझे महांती ही ना को मिस्टर महांती देखो से मत आनी दौरान अब बेसी मैट्रिमोनियल मैटर जो हियरिंग होची तो सब केशवानंद भारती भाई हो गलानी घंटे 1.5 घंटा से तापर आ बेंच क्लर्क की अवस्था गलानी कोर्ट मास्टर कर बेंच क्लर्क को
बोल दे दी हो
किछि दरकार your lordship may pass this order this
same order same passed in your case but there is no point in keeping these matters pending also.
Right, sir.
Another item 26, Lord. That is similar matter.
Same order may be passed.
Okay. For disposal order तारा गोटे copy रखी दियो. Mr. Ray, you have a copy of that order disposal? No. Hey, आपने xerox करके दिखाई दे. So Mahapatra, kindly give some time. We'll make a copy and return.
So item number 12 and item number 26 both are disposed of.
Okay.
Yes, ma'am. Obligement.
Yes. Next. So rest of them, I actually had some assignment. So by continuing the hearing, it will become difficult.
Only my matters are this present matter just now that the execution proceeding has been initiated. Only it may be taken up any time or for that stay of that execution.
Stay, sir, matrimonial matter stay problem.
No, sir, matrimonial way. In a present different means.
Sorry, which item?
13, this matter just now. Which has been called up.
No, it is the corona कर रहा ना.
On behalf of Mr. Madam is there. Yes.
Sorry.
Sir, what happened? This is a case where the wife has also filed a divorce petition against the husband. This is a case. And similarly also wife is also serving in a bank, HDFC bank. Sir.
Mr. Panda.
Sir.
You have heard Mr. Dhara, Mr.
I have to my lordship's mentality से तो मैं पूरा acquainted. किसी एक deviation नहीं. Only case is here is a case where the husband is unemployed, interested to take back her wife as well as her son. The divorce petition is filed by the wife despite the repeated request by the husband itself.
सेटा available नहीं है. सेटा same period आपनकर I cannot make the wife company to stay.
There is no
केते आपनकर केते आवाज नाम केते
सर खूब कम अच्छे बेसी
8,000.
हाँ 8,000
8,000 टोटल केते ड्यू होला सेटा स्टेट गोटे लाइन करतो ना
हाँ केते 1 lakh something
Or it is an interim order, your lordship.
correct 8,000 for how many months
88 months, my lords.
कितने मास
On BC, your lordship, appearing for the respondent.
38 months
Yes, your lord.
3,04,000
केते
40 मास हेले धरंतु 3 लाख 20,000
आगे
16,000 फेरी दियंतु
2 लाख केते हिजो 2
ना
लाख
ना ना आपण मैथमेटिक्स बहुत
भूल नहीं ए बार लिखा है 3 लाख 2 lakh 16,000 अच्छी अच्छी एटा दैट इज देयर
सर केमती करछंती से ताकर मैथमेटिक्स बहुत जो कैलकुलेट करछंती
ओहो
8,000 टका 32 मास
3,25 that is there only thing is that the wife is not unemployed she is drawing 70,000 rupees per month that is she is also serving in HDFC bank for that reason she is also ignoring the husband because he is unemployed that is the reason despite the
पैसा को आपण पैसा को कासो
सर को देबे
तो छाड़ दियंतु छाड़ दियंतु एतरे मत भर्ती करंतु
आगे
वेरी डिफिकल्ट आपण जदी सिक्योर करिवे केते टका आनी सुनंतु प्रॉब्लम कोन अछि आपण माने ए कथाटा डिस्कशन करिया कथा आपण चेंबर रे
डिस्कशन सर ठीक है
सर टिके गोटे मिनिट
आगे
आपण तो डिसाइड कर परिबे
ना ना नेवर
जज डिसाइड कर
आगे
आपण पचारंतु मैटर एडजस्टमेंट मिल जात
ना आगे तो ऑब्वियसली काई ना आपन डू इट
सर सुन आपण जदी मु डायरेक्शन देबी आपण कंप्लाई करबी कंटेंट हो जिवो
दैट इज देयर
CP रे अछि appellate court has the power for enforcing it
ठीक है CP is pending now the it is in at the stage of final hearing
आपण 3 लाख टका ने केटा देबे पचरी गया
दे पर आदो टोका दे पर बिकॉज़ आपने प्रोडक्ट
छाड़ दो
आगे
एडजस्टमेंट कुछ एडजस्ट कर दियो
आगे यस
केरो तेरा के एडजस्ट कर देल
पूरा लंबा डेट दी
से लंबा डेट नहीं
आगे
अरे अदर साइड को मन अच्छी बुझी ना कौन
ना दर्शन अछन
तू तो कहले कि अदर सबमिट तो अदर साइड तक
उधर में चाहूं कि
दुकान अदर साइड है
आगे आगे
से कोई भाई आप एडजस्ट करी
sir dealt with cases no not even a single case where the wife has filed a divorce against husband this is the solitary case whereas wife does not file a divorce
सेटा गोटे आपण पब्लिक फोरम रे स्पीच रे
speech go sir mona let them say deny no the divorce
देखो पैसा पत्र कथा रे आपण दबार अछि ना मोर नबार अछि कि
ना ना
सुन आपण सेतरे बिल्कुल पसंद नहीं आपण गोटे केबे चाहते मिस्टर चेतन केबे लंबा डेट
आगे लॉर्डशिप दिस मैटर
केबे आसे हबो एडजस्टमेंट
आगे 20 तारीख को अछि जो ये प्रोसीडिंग रो
20 तारीख फरवरी
यस दिस 20
ठीक आपण प्रोसीड करू
हां मैं लास्ट टाइम ओनली
दिस कोर्ट इज नॉट
इम्प्लीमेंट
April मास नो सिंपली कहंतु नहीं डोंट डू दैट लुक्स सो हार्ड
आगे
they are saying you are saying
any date में फिक्स
ना हम
we commencing 9 मार्च कर दियो
डेट
ठीक है सर आप 25 मार्च कर दो
माय लॉर्डशिप में फिक्स डेट
सर कर दो
sir copy of the adjournment order shall be forwarded to the executing court the adjournment is sought for by the lawyer counsel for the petitioner who is in default of the awarded amount which comes to rupees 3,04,000 on being asked how the petitioner will secure the amount which is in the nature of a money decree into bracket Rajneesh versus Neha
लॉर्डशिप बट फिक्स डेट
bracket close the lawyer counsel for the petitioner seeks adjournment to obtain instruction
लास्ट वीक मार्च करो
accordingly the matter is posted to
लास्ट वीक
shall be listed in the week commencing 9 March 2026 copy of this order shall be forwarded to the lawyer so and so court with the execution pending is forward करो
सर 9/5
ना 9/3
9/5 करिए
9/3
ठीक है सर 25 दिन कर दियो
सर टका आनंतु काली
सर टका 25 दिन सर नहीं जो 25 दिन दे दो बोलो सर
हेलो
yes orders matters it will be listed but it will be listed on 17th all orders matters will be added to 17th only formal orders can be taken up that's a different thing
item number 24 my order
yes orders are sorry take one second now is the orders matter
item number 17
yes
this is a condolence note delayed only for 7 days notice has been sought there is a notice
sir say defaulted amount Mr. Ponda bahut ragi loko ଆପଣ defaulted amount କହିବେ କେତେ ଟଙ୍କା ଦେବେ କହିବେ
17
Mr. Pandal will not spare
17 related common 7
अच्छा ठीक है डिलीट कर दियो
item number 9
ना सर कुछ 17 को आनिया पे आइटम 17 हां 17 कहले ना
19
ଆପଣ
फॉर्मल जो दिन आस्ट मु कहली आपण 7
नहीं 17 ना पर जेबे भी आसे चलो आ तो जेबे आपण यू आर फ्री ठीक है
item number 19
हां 19
nomenclature has been wrongly I has been filed different
এটা আফি ফর্ম হবল এটা হিসব
ଆଜ୍ଞା
মিস্টার হিমাংশু ভূষণ আইটেম 19 লিখুন মিস্টার হিমাংশু ভূষণ সুতার ফর দ্য পিটিশনার IA 506 of 2025. The IA has been filed for correction of the nomenclature as mentioned in the cost title of the petition. Subpara. The stamp report dated 6/7/2024 indicates that the petition to be registered may be registered as WPC. Within court this may be registered as WPC quoted. For admission to Hard on counsel for the petitioner. The petition is allowed. The petitioner shall have liberty to file petition giving the correct nomenclature. Within how much time sir? कितने दिन में file करिए?
yes it's
exact. The petition further 2 weeks time granted to take steps. जहाँ करिया कथा ही करियो. Yes.
Beg pardon. Item 14. Can it be taken up? Yes, madam. The date may be fixed. Condonation of delay, my lord. Your lordship was not inclined to condone the delay. The petitioner they want to withdraw the application. One.
Mr. Bose तो थिले.
Yes, madam.
से कौन लगी देख Mr. Bose टेबल तले देखु थिले. ते 4,50,000 जो प्रथम रो जिंसडा बिगड़ी गला. तापर से चलला से कहले बेटर होची आज लॉक करिया.
Because of pendency of the
कौन Mr. Bose रे एसोसिएट करे गले.
Date may
be डेट कर दियो तो. केबे केबे चाहूँ.
Short date may be fixed, my lord, because of pending.
pending 17 को रखू. देख.
My lord.
17 तारीख को रख देता हूँ. Simply posting कर दो. आपन को मैडम? Yes.
Deeply obliged.
Item number 18.
Yes, 18.
And medicine center man.
ना मेंटेनेंस से मेडिसिन को मत देव पड़े पैसा अरे मेंटेनेंस से आपण कोन मेडिसिन कोन होपर आपण मन जो एग्री करछन कहि दियंतु जण आर करछन जण आस्थिले मैडम केम एंड सी सेड दैट आई वी आर गोइंग फॉर मेडिसिन कोन कथा
I love maybe possibility of one.
आपण केते टाका देबा कथा केते टाका ये अन्य मैटर ताले काहे तो सब मैटर तो मेडिसिन को वेरी डिफिकल्ट मेडिसिन रे को राजी हो नान तापर
Item 36 my lord. Item
थाउ जेबे का आसीबो अर्जन हे गला
my lord, item 36 my lord.
Once I have not gone to that page. Yes, madam. Item 18.
Your lordship, last time limitation petition hearing ପାଇଁ ଥିଲା ଆମେ objection file କରିଛୁ your lordship.
Okay. से mention करूथिले medicine ପାଇଁ but I have not passed any order. It is adjourned. पर ଗୋଟେ date तो ताले
oblige your lordship.
कमेंट करछंती आगे we commencing 16 दिन madam.
Oblige your lordship.
16 दिन madam. बड़े पढ़ो
item
6 ଗୋଟେ mention କରୁଛନ୍ତି ଆପଣ କେତେ 20 ପାଲଟା ସିଂ yes कोन କରୁଛନ୍ତି
I had it is for
डेट चाହୁଛନ୍ତି कर दियନ୍ତୁ କେବେ
we commencing 23
मार्च ना फेब्रुआरी चाହୁଛନ୍ତି
नहीं फेब्रुआरी ଗୋଟେ short
ତାହେଲେ 23 ବି कर दियନ୍ତୁ ହେଲା ठीक ଅଛି नेक्स्ट 21 के कोड मेंशन କରୁଛନ୍ତି
24 my lord.
Yes.
That case, my lord, that matter was before lordship, my lord, day before yesterday, my lord. In that case, what happened to this honorable court directed parties for mediation, my lord. And also the directed London family court to fix a date beyond the week commencing from 9th. That is why, my lord, London family court Bhubaneswar the date to 16th for argument, final argument. In the meantime, my lord, date fixed to 17th of January for mediation. That mediation failed, my lord. So that is the came before lordship, my lord. If you lordship final order.
आपन ट्रायल कोर्ट रे केबे डेट अछि कहउछंती
अछि 16 तारिख फाइनल आर्गुमेंट पे अछि
16 2
16
3
No, my lord. So 16th of this month, my lord. February.
ଅଦର ସାଇଡ୍ ନାହାନ୍ତି
ଅଦର ସାଇଡ୍ ନାହାନ୍ତି ତାଙ୍କର କିଛି ଏଥିରେ କହିବାର ନାହିଁ
କାଲି ତାହେଲେ କାଲିକି ରଖନ୍ତୁ
ତାଙ୍କ ପିଟିସନ ଉପରେ ସାର୍ ମେଡିଏସନ ଯାଇଥିଲେ ମେଡିଏସନ ଫେର ହେଲା
ଏଟାକୁ କାଲି ଅର୍ଡର୍ସକୁ ନେଇ ଆସନ୍ତୁ ହେଲା କାଲି ବେଞ୍ଚ କଣ ହବ ମୁଁ କହିପାରିବିନି ମତେ କାଲି ଆଣନ୍ତୁ ତାହେଲେ ସେ ଅଦର ସାଇଡ୍ ନାହାନ୍ତି ନା ଯଦି ଉଭୟ ପକ୍ଷ ରାଜି ହେଇଥାନ୍ତେ ତାହେଲେ ମୁଁ ଯାହେଲେ କରିଥାନ୍ତି ନାହାନ୍ତି ତାଙ୍କ ଆବସେନ୍ସରେ କରିବାନି ହେଲା 24ଟାକୁ କାଲି ଟିକେ ନେଇ ଆସନ୍ତୁ ଗୋଟିଏ ମ୍ୟାଟର ରହିଲା 26ଟା ତ ଆପଣ ଡିସ୍ପୋଜାଲ ଅର୍ଡରଟା ସେ ଦେଲେ ଜେରକ୍ସ କରି ମହାପାତ୍ର ଠିକ ଅଛି 27 ରୁ 33
My lord, I do 23.
sir
23 family pension matter. Counter has not been filed. Let them file.
ଡେଟ୍ ନିଅନ୍ତୁ এটা আপনার নোটিস হিয়ারিং ম্যাটার না কেবে মার্চে ଗୋଟେ ডেট
This matter, my lord.
31st March.
କରନ୍ତୁ
This matter, my lord.
31 ମାର୍ଚ୍ଚ ହେଲା
ସେ counter ଟା file କରନ୍ତୁ counter ଟା file
My
କରନ୍ତୁ
lord, this matter, my lord, issue is pending before the division bench. May I?
ସେ ଆସୁ ଦେଖିବା ଆରେ
Division bench, the same issue is pending.
ସାହୁ ଆରେ I'm not taking up on merits already
Yes,
time
my lord. Yes, my lord, I'm just saying, my lord. Matter
ତ
is.
ଆସୁ ଦେଖିବା
Aଜ୍ଞା. Yes, my lord.
ନେକ୍ସଟ ପେଜ 4 ରେ କାହା କିଏ ମେନସନ କରୁଛନ୍ତି
My lord, at 36.
36
My lord may be taken up for 9th, my lord, because minor son has filed for school fees.
9th of March କରୁଛନ୍ତି
My lord.
ଠିକ ଅଛି କରିଦିଅ
Oh, blessed. My lord.
সেটা actually page 4 5 page 4 ରେ 27 ରୁ 33 then 34 ରୁ 37
I mentioned 36.
she has noted ଆପଣ note କଲେ Mr. Parikh madam mention କଲେ 36 9th of March we commencing 9th yes madam yes ଆପଣଙ୍କ madam
41.
ହଁ ଡେଟ୍ ଚାହୁଁଛନ୍ତି ନା କୌଣସି ମ୍ୟାଟର ଡିଲିଷ୍ଟ ହବ ନାହିଁ ଅଲ୍ ମ୍ୟାଟର୍ସ ଆର୍ ଇନ୍ ଦ ଲିଷ୍ଟ ବି ଆଶ୍योर ବଟ୍ ଆପଣ ଯଦି ସ୍ପେସିଫିକ୍ ଡେଟ୍ ଚାହୁଁନାହାନ୍ତି ଛାଡ଼ି ଦିଅନ୍ତୁ ଇଟ୍ ୱିଲ୍ ବି ଡିଷ୍ଟ୍ରିବ୍ୟୁଟେଡ୍ ଫାର୍ଷ୍ଟ ଫ୍ରେଶ୍ ଆଡମିସନ ସରିଛି ଅର୍ଡର୍ସ ଆସିଯିବ ତାପରେ 17 ତାରିଖ ବେଳକୁ ଯେତେ ଆଡଜଷ୍ଟ ହେଇପାରିବ 17-18 ଆଡଜଷ୍ଟ ହବ ତାପରେ ତ ଗୋଟେ ୱିକ୍ ରହିଲା ତାହେଲେ ମାର୍ଚ୍ଚକୁ ଯାଇକି ଡିଷ୍ଟ୍ରିବ୍ୟୁଟ ହେଇଯିବ ମିଷ୍ଟର ସାହୁ
Lord, we both are here, my lord. I am for the respondent
hearing
and
matter.
for the appellant.
you want a date
Yes, my lord, a date.
It can be
Second to-
closed off.
that interim order remains on first once had মানে finished hearing means କେବେ ଗଲେ ମାର୍ଚ୍ଚ ନା ଏପ୍ରିଲ 6 we commencing 6